I want to take the one.
بسم الله الرحمن الرحيم والصلاة والسلام على سيدنا محمد.
Be upon his messenger, kith and kin. Your Highness, Your Excellencies, ladies and gentlemen, esteemed guests, peace be upon you. We are pleased to welcome you in the opening of the International Model for Islamic-Based Construction Contract, IBCC, organized by the Islamic Council under the patronage of His Excellency the Minister of Justice Abdullah Al-Naimi and the Department of Experts and specialists in the Islamic economy and arbitration and engineering, and from the different regional and national and international entities. This conference comes to crown the academic and professional efforts extended over years of unwavering work to prepare a model contract for the and inclusive for the construction, aligning with the Sharia, Islamic Sharia, and achieved balance and fairness and equity between the parties of the contract. This embodies the position of the Islamic Center in arbitration and resolution and enhancing Islamic Sharia that contribute to transparency and equity and building trust in the international Islamic economy under the vision of the UAE, which puts in its front lines to consolidate the legal and economic pioneering and consolidating innovation in different development sectors. We witness a critical time in the trajectory of the Islamic contracts. This conference launched the international model of Islamic-based construction contracts, IBCC, under balanced clauses and innovative methods of ADR. Ladies and gentlemen, we start our conference by reciting some verses from the Holy Quran by Mr. Anas Rashid. The floor is yours.
محل الصيد وأنتم حرم إن الله يحكم ما يريد يا أيها الذين آمنوا لا تحلوا شعائر الله ولا الشهر الحرام ولا الهدي ولا القلائد ولا آمين البيت الحرام يبتغون فضلا من ربهم ورضوانا وإذا حللتم فاصطادوا ولا يجرمنكم شنآن قوم أن صدوكم عن المسجد الحرام أن تعتدوا وتعاونوا على البر والتقوى ولا تعاونوا على الإثم والعدوان واتقوا الله إن الله شديد العقاب.
Ladies and gentlemen, esteemed guests, we call the Secretary General for the Mr. Rami Siman Abu Dakka, the Secretary General of the Center, to give an idea about the Center. The floor is yours, Mr. Abu Dhaka. In the name of Allah, the Compassionate, the Merciful. Praise be to Allah and the peace of blessing and upon His messenger, kith and kin. Praise be to Allah who established the balance of justice and commanded us to fulfill contracts, saying, O you who have believed, fulfill your contracts, and peace and blessings be upon one of who was sent to the mercy to the worlds, and the seal of the Prophet Muhammad, who taught us Muslims are bound by their stipulation, except the stipulation that recognizes the prohibited or practice of legal. Your Excellency Abdullah Sultan, Naimi Minister of Justice, United Arab Emirates, Your Excellency Professor Jassim Ali Shamsi, the Chairman of the Center Board, your esteemed representatives of the institutions and bodies participating, sponsoring, and collaborating with the Center, ladies and gentlemen, honorable audience or attendees. We convene once again for the edition of this Center's annual international conference titled Launching the Model International Islamic-Based Construction Contract, IBC 2025, held under the slogan that summarizes the vision of a global balanced ideal clauses and innovative mechanisms of dispute settlement. It is well known that contracting and construction sector is no longer just a secondary or marginal sector. Rather, it became a key driver and a main arbiter to economic development, where the investment and construction meet. It is important field where the interest of projects owners, real estate developers, contractors, and development agencies or other entities convey. Amidst these articulate relationship, contracts remain the construction and the safety value, especially in the countries facing legislative shortcomings. However, the practical reality today shows an increased number of contractual disagreement disputes due to the injustice, ignorance, and deception in the field of construction. For years, the reality inspired we propose an integrated Islamic contract model that balances the interests of all parties and based on the noble principles of the Islamic justice of fairness, and simultaneously keep pace with the latest global engineering legal participants. I present this idea to several experts and special field until the will of Allah Almighty. I met with brother engineer Kamal Adnan Malas, who immediately adopted the approach and dedicated the effort of expertise. And we reached the IBC 2025, which represents the reforming vision and inclusive vision based on the spirit of Islam to build relationships by goodwill and cooperation, and seeks to reduce the disputes, and if they happen, the contract transfer them to the amicable and institutional arbitration in a short time and in a low cost possible. And it will be clear to us the main objectives of the conference that are represented in the following. First one, establishing standards of balance and justice in drafting construction contracts, far from any injustice or uncertainty or ignorance. Secondly, enhancing integration between Sharia engineering and legal experience to draft an integrated model contract to be a reference in this Islamic world and beyond, particularly in the countries that adopt the civil law system. Thirdly, developing innovative mechanisms for dispute settlement based on the principles of arbitration and conciliation in a Islamic civilized spirit. Ladies and gentlemen, this conference, with the participation of an elite of a group of scholars and jurists, experts, and participation, represent a participating step, a practical step toward the objectives, where the minds and expertise meet to put a mark in building a development Islamic thought in construction that contribute to develop economy and boost trust and makes an international model to be followed in transparency and integrity in the jurisprudence of the transactions that Allah revealed to us. And it was ahead of a lot of the legal systems nowadays to consolidate the contractual equity and protecting the rights. And we need to revive this legacy with a temporary spirit that boosts the Islamic legislations. And we put a methodology and the sessions of this conference that align with these objectives of the conference. And in the second day of the conference, we will hold specialized sessions presented by competent people that touch the legal and legislative and engineering sides and technical fields for the model construction contract IBCC 2025. In conclusion, I would like to thank and appreciate all those who contributed and helped in the organization of this conference, and to those all experts and speakers and participants who participated in drafting this model contract, which is the first of kind internationally, and which inaugurates the center its session of contracts, model contracts, afforded by its objectives to develop the Islamic economy as the arm of the legal for the financial Islamic industry. We wish that, we ask Allah and pray for him to make our work for his and guide us to the goodness and bless this conference and its outcomes. Thank you so much for listening.
Ladies and gentlemen, now invite you to watch a video that shed light on the objectives of this conference and the main pillars of this conference.
خطط وأهداف المركز الإسلامي الدولي للصلح والتحكيم باعتباره الذراع القانوني الدولي للصناعة المالية الإسلامية، وتفعيلا لما أعلنه المركز في سنة 2024 بشأن مباشرة العمل على إطلاق العقد الإسلامي النموذجي لقطاع المقاولات. تم بحمد الله إعداد العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 الذي يتوقع أن يساهم في تحسين بيئة الأعمال وتعزيز الثقة بين الأطراف المتعاقدة في قطاع المقاولات، خاصة في الدول التي تطبق القانون المدني بما لا يتعارض مع أحكام الشريعة الإسلامية. مراحل صياغة العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025. بتوجيهات من مجلس أمناء المركز، شكل أمين عام المركز الدكتور رامي سليمان لجان عمل متخصصة لإنجاز المشروع برئاسة المهندس الدكتور كمال ملص، حيث تم تحديد الأطر العامة للعقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 ووضعت محاوره الرئيسية، ثم تداولت لجان العمل أحكام البنود التعاقدية بالتفصيل، وعرضت تلك البنود على التدقيق الشرعي، ومن ثم عقدت جلسة استماع حضرها العديد من الخبراء في المجال، حيث ناقشوا مسودة العقد وقدموا توصياتهم من واقع التحديات العملية التي يواجهونها. وأخيرا وبإشراف وتنسيق عالي المستوى بين كافة اللجان المختصة وعدة جهات محلية ودولية، تم إقرار الصيغة النهائية للعقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 على النحو المعلن عنه، والذي يخدم مصالح جميع العاملين في قطاع المقاولات ويقدم لهم أداة قانونية موثوقة وفعالة. أبرز مزايا العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025. لقد تبنى العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 أفضل الممارسات المعتمدة دولياً، وقد حرصنا على تجنب أي ثغرات قانونية أو فنية أو شرعية قد تعيق أطراف المقاولة من تحقيق أهدافهم، كما حرصنا على أن يكون العقد خاليا من أي غموض أو غرر أو جهالة، وأن يكون محكما ومبسطا يسهل على مستخدميه من مستثمرين ومطورين ومقاولين واستشاريين إدراك أحكامه. آثار العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 إقليميا ودوليا. يعد العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 خطوة رائدة في دعم وتطوير وازدهار قطاع المقاولات الذي يعد أحد أبرز قطاعات الاقتصاد التقليدي منه والإسلامي، وقد خصص المركز داخله قسما يعنى بنشر العقد على كافة المهتمين للعمل بموجبه وتلقي الاستفسارات حوله والإجابة عنها، كما سيهتم بتلقي التوصيات والمقترحات لإصدار نسخ أخرى منه في الأعوام المقبلة لتواكب التطور الذي يشهده قطاع المقاولات عالميا. ختاما، إن إطلاق العقد الإسلامي النموذجي لقطاع المقاولات IBCC 2025 وغيره من المشاريع والمبادرات التي يعمل المركز على إنجازها ما كانت لتتم دون توفيق المولى عز وجل، ثم دعم المؤسسة الأعضاء وتكاتف جهود كافة الخبراء القانونيين والشرعيين والفنيين ممن ساهموا في تحقيق هذا الإنجاز، والذين نوجه لهم جزيل الشكر والتقدير. ولا يفوتنا أن نشكر دولة الإمارات العربية المتحدة وحكومتها الرشيدة وبالأخص وزارة المالية على استضافة ودعم المقر الرئيسي للمركز منذ تأسيسه، مؤكدين للجميع بأننا مستمرون في أداء الرسالة وتحقيق الأهداف المنشودة في خدمة الاقتصاد الإسلامي والرقي به ليتبوأ المكانة العالمية الرائدة. كما نعمل على المساهمة في تحقيق استراتيجية الإمارات للمالية الإسلامية وصناعة الحلال للسنوات الست المقبلة 2031 التي أطلقها مؤخرا صاحب السمو الشيخ محمد بن راشد آل مكتوم نائب رئيس الدولة رئيس مجلس الوزراء حاكم دبي حفظه الله ورعاه.
الحضور الكريم، نستمع الآن إلى كلمة رئيس مجلس أمناء
Head of the Trustees Council, Professor Jassim Ali Shamsi. Mr. Jassim, the floor is yours.
Peace be upon you. In the name of Allah, the Compassionate, the Merciful, and praise be to Allah, and peace and blessings be upon His messenger, kith and kin. And all who follow His path and guided by Him until the Judgment Day. Under the patronage of His Excellency Abdullah Sultan Al-Naimi, the Minister of Justice in the UAE, and on behalf of Professor Ubaid, the representative of the Minister of Justice, Your Excellencies, and the members of the Supreme or Senior Administration and the financial institutions, and the construction companies and the consultants. The esteemed representatives of the institutions and the bodies participating, sponsoring, and collaborating with the center, ladies and gentlemen, esteemed guests. It is my pleasure today, in my capacity as the chairman of the Board of Trustees of International Islamic Center for Reconciliation and Arbitration, IICRA, and on behalf of the board of members, to welcome you to the third edition of the Center's International Conference titled The International Model for Islamic-Based Construction Contract, IBCC 2025. balanced, ideal clauses, and innovative mechanisms for dispute settlement. Thank you for your attendance and participation. I highly appreciate the efforts of everyone who endured the difficulty of traveling from abroad to be with us at this important event, which hosts a distinguished elite of engineers, contractors, accountants, Sharia scholars, and legal practitioners from the UAE and beyond. I also extend my thanks to ADIB for their generous sponsorship of the conference. My gratitude also is extended to all the entities participating with the preparation and organizing, such as the Judicial Training Institute, Ministry of Justice, the Arab Union of Real Estate, Investment and Development, Sharjah Islamic Economic Center, and Dar al-Sharia. I pray to Allah Almighty that all these efforts are crowned with success and guidance. In this center, of course. Your Excellencies, ladies and gentlemen, esteemed guests, our meeting renews this year following the success of Center's previous international conference, where the project to draft the international model for Islamic-based construction contract was launched. This was undertaken due to the importance of contracting and construction sector, which is witnessing rapid development. This development necessitates efforts to strengthen its legal structure through the issuance of organized and robust laws and legislations, a role assigned to the regulatory and legislative bodies. Furthermore, it requires the preparation of balanced, ideal contracts that are far from injustice or dhulm, excessive uncertainty, gharar, or lack of clarity, jahala, the very standards accompanied by the noble rules of Islamic Sharia. Therefore, it was incumbent upon the center to exclude this important project, as it represents the legal form of Islamic finance industry. As someone deeply interested in the academic and research aspect of the contracting sector from the Sharia perspective, having diligently researched the contractual relationship between contracting parties for years, I have found that IBCC 2025 in its current draft to be the most balanced and of contracts, and the one that best avoids the loopholes that are common in other contractual contracts. This will make the IBC distinction and indeed a reference for all stakeholders aspiring to protect their rights, particularly in countries that apply civil law system in a manner that does not conflict with the principles of the Islamic Sharia. In conclusion, we hope to achieve the desired goals of the conference in the manner that benefits the Islamic financial industry in general. I must renew my thanks and gratitude to the contractive drafting committee represented by Dr. Kamal Malas for their blessed efforts in preparing this effort, and also our thanks are extended to the supporters and the participants in this conference, and we pledge to continue striving to fulfill the mission and objectives of the center, as it is one of the most important institutions in the infrastructure and legal arm of the Islamic finance industry. Thank you so much.
Ladies and gentlemen, now we listen to the speech of His Highness Abdullah bin Sultan Awad al-Naimi, the Ministry of Justice, the patronage and host of this conference, presented by, on his behalf, the Mr. Abaid bin Theresa al-Gimsi. Mr. Your Highness, the floor is yours. In the name of Allah, the most compassionate, the most merciful, peace be upon the Prophet, our Prophet Muhammad, and his kin and his followers. Your Excellencies, ladies and gentlemen, greetings to you all. I convey to you the greetings of His Excellency Abdullah Sultan al-Naimi, the Ministry of Justice, and his apologies for not being able to attend due to some emergency. I'm delighted to be here with you in this distinguished event, which witnesses the launch of the international model of Islamic-based contract, IBCC. This contract is organized by the International Islamic Center for Reconciliation and Arbitration. This pioneering step reflects the depth of our rich Islamic legal heritage, its capacity to keep pace with developments, its intellectual richness, and its ability to handle arbitration. Ladies and gentlemen, Islamic jurisprudence has always been distinguished by its supreme accuracy in conceiving contracts and expressing its concept. Its rulings are founded upon the principle of mutual consent and negotiation. Islamic jurisprudence was, in the fact, the first to accurately express the effects of a contract at time when Roman law had not yet developed a correct concept for it. Indeed, the European laws that would draw inspiration from the continuing the same path, which eventually led to the issuance of the FIDIC model. From here stems the importance of the model international contract for construction agreements compatible with the Sharia provisions, considering it as a valuable step towards unifying concepts regulating the contractual practices in the Arab countries. It's integrated with the international and Islamic standard upon the disciplines, foundations derived from our rich jurisprudential heritage, while simultaneously providing framework that respects Islamic law. It is important to point out at the role of our wise leadership, which always have a forward-looking vision for the future. Since the establishment of the United Arab Emirates, our nation has established itself as an ambitious young nation, setting up legislations that reflect its standard as a global hub for a diverse culture and businesses. The UAE has proactively adopted a stance toward issuing laws and regulations that provide distinguished business environment, enhance efficiency, competitiveness, and innovation. On one hand, it protects sustainable development and well-being of the society on the other hand. Based on this advanced legislative approach, the UAE Civil Transaction Law stipulates in its second article that understanding the text should be based on the rules and principles of Islamic jurisprudence. It understanding and interpreting the text, this reflects the Emirati's legislators' understanding of the importance of Islamic jurisprudence as an authentic source of civil legislation. Furthermore, the Federal Decree Law Number 31/2021 Penal Code emphasized the importance of this contract. In conclusion, this initiative represents a qualitative addition to the efforts aimed at strengthening legal cooperation and consolidating the principle of justice and construction contract between Islamic countries, thereby achieving sustainable economic development. Thank you for listening, and I welcome you again. And the Minister of Justice sends his greetings to you all. Greetings to you all. Ladies and gentlemen, now to the speech of the head of the drafting, Dr. Kamal Adnan Manas. Kamal, the floor is yours. In the name of Allah, greetings to you all. Peace be upon our Prophet and his followers. Your Excellency Abdullah, Minister of Justice in the UAE, Your Excellencies, ladies and gentlemen, greetings to you all. It's my great honor on behalf of the International Islamic Center for Reconciliation and Arbitration to extend to you all the warmest welcome to this historical occasion, which we proudly hold under the patronage of His Excellency Minister of Justice in support of the ongoing journey of legislative and economic innovation in the UAE, a nation that has always been at the forefront of foresight and leadership, and a pioneer in building a just and integrated Islamic economy. In line with the vision of the UAE to be a global leader and inspired by the guidance of His Highness Sheikh Mohammed bin Rashid Al Maktoum, Vice President and Prime Minister and ruler of Dubai, may Allah preserve him, who has always directed that Dubai must be #1 in all its initiatives and achievements. The International Islamic Center for Reconciliation and Arbitration took the initiative to launch a pioneering projects and innovations that are the first of their kinds in the world. From this vision emerged the idea of developing the model Islamic-based construction contract, a groundbreaking global project that reflects its inspired vision and translates it into a practical and legal framework serving the international Islamic economic system. To become an international project that reflects this vision and turn this vision into reality that serves the economy. And I was honored to honor this effort. Our gathering today marks a world-first milestone in developing a contractual framework that is fully aligned with the principle of Islamic Sharia, which always being compatible with civil law adopted in countries that apply civil law and incorporate Islamic Sharia within their constitutions, and also countries that embrace Sharia. The drafting committee of this contract, which I have the honor to chair, has worked diligently for an entire year in collaboration with distinguished group of scholars, experts, and legal specialists from various countries. Since the initiative was first launched during last year's conference, your patronage and support of this blessed project embodies the wise vision of the UAEs in supporting legislative and economic innovation in the Islamic sphere, and reaffirms that UAE has always been and it continues to be a beacon of peace, justice, and sustainable development throughout the Islamic world. We pray that Almighty Allah grants us a success in serving the noble objectives embodied in this contract, and that it is going to launch today. In conclusion, thanks to everyone who helped us achieve this contract, which is a very important step in contracts worldwide. Greetings to you all.
Ladies and gentlemen, we will listen now to His Excellency Dr. Muhammad Mahmoud Al-Kamali, the Director of the Judicial Training in the Ministry of Justice. The floor is yours, Mr. Kamali. So we will leave you with remarks with Mr. Yasser Hosseini, the Director of the Sharjah Center for Islamic Economy. The floor is yours, Your Excellency. In the name of Allah, the Compassionate, the Merciful, peace and blessings be upon His Messenger Muhammad, kith and kin. Your Excellency Abdullah bin Sultan Al-Nuaimi, the Minister of Justice, Your Excellency Ubaid Al-Gamzi, the Director Assistant for the Ministry of Justice, Your Excellencies and esteemed guests, peace be upon you all. We thank Allah that helped us to meet together in this blessed conference, with which oversight perspectives in the industry of the Islamic contract. And we pray to Allah to guide us to success. I am honored to stand before you in this blessed meeting in the International Model for Islamic-Based Construction Contracts 2025, IICRA, represented by the Center of the Resolution and Conciliation Center in Dubai, and in the patronage of the Ministry of Justice in the UAE. Ladies and gentlemen, the sector of construction is the vein of development and the nerve of the economies, and we all know what this sector faces from challenges and loopholes, particularly under the international systems, legal systems that may not completely meet the needs. From this point, the importance of this model comes, and it is not only a document, but it is an inclusive and integrated vision that aims to draft balanced documents and put mechanisms for reconciliation and arbitration. This contract is a critical and transforming point because it has resolutions to bridge the gaps and focuses on the model construction contracts that realize equity and fairness that align with the Islamic Sharia rules. What is distinguished in this contract is its jurisprudence deep depth, and its objective is not only on the form alignment on the with the Islamic Sharia, but to achieve the mega Islamic provisions. The objectives of the Islamic Sharia is to achieve equity and fairness among people, and this contract guarantees the rights of all parties that consolidates the equity and the rights of contracts. And by taking into contract the provisions of the Sharia transactions, like, for example, emergencies, because it represents a model that relates the legal and the Sharia commitment. Ladies and gentlemen, the Islamic Sharia allows the financial contracts as they have a lot of objectives, and we are keen to talk about this international contract for the construction contract that align with the Islamic Sharia provisions, to mention some of these lessons and the provisions. And one of the provisions of the Islamic contracts is to achieve equity and fairness among all the parties of the contract. So fairness is an objective guided by Allah, saying Allah orders us to achieve fairness and equity, and the books are revealed to the messengers. As said, we sent our messengers with their books and knowledge and balance to achieve fairness among people, and Muhammad, peace be upon him, consolidated that, and he forbidden usury, and he allows the sale. And if you repent, you will have your capitals, you will not be unfair and you will not be unfair. And the objectives of the financial contracts, the credibility, there should be clarity and credibility and avoiding conflict, and from this we should document and witness the contract so that all people will be knowledgeable and cognizant of the contract provisions. And one of the Sharia, Islamic Sharia, to achieve the interest and raise the any jurisprudence or any prejudice, as stipulated by the scholars, which is the deliberation of money and preserving them and achieving equality and equity in these funds. Last but not least, I thank His Excellency Abdullah Sultan Aimi, the Minister of Justice of the UAE, for sponsoring this important conference that adds a value, academic value, and thanks are extended with respect and love and appreciation to the Islamic Center for Conciliation and Resolution for his innovative initiative, hoping that we will meet again together soon. Peace be upon you, and thank you for listening.
We would like to welcome you again, ladies and gentlemen. Now the collaboration agreement signing that between the center with our partners. We invite Professor Jassim Shamsi, the chairman of the trustees, to the stage to sign the contracts or the memorandum of understanding. The memorandum of understanding in collaboration with the Asian Center, represented by Tak Jahan, the executive manager of the center. The executive manager of the center, you may come to the stage to sign the memorandum of understanding. The collaboration agreement with the Islamic Center, and the manager of the center couldn't make it to the center, therefore it will be signed online. Now we move on, ladies and gentlemen, to the honoring stage where we express gratitude to whoever helped us to make this possible. We invite Jassim Shamsi to honor and recognize the sponsors. We start by recognizing the Minister of Justice, represented by the Undersecretary Abeid Al-Ramzi. We honor and recognize the head of the chairman of the trustees, Dr. Ali Jassim Shamsi. We honor the golden sponsor, Adib, represented by Mr. Khalid Al-Mansouri, the executive manager of MBM Real Estate Company. Honoring, recognizing the Minister of Finance, represented by Yunus Khoury and received by Faisal Al-Mansouri. Honoring and recognizing the organizers, starting with the Jurisdiction Training Institute, Mr. Al-Kamali. Islamic Economy Sharjah Center, represented by Yasser Al-Hosni. Arabic Union for Investment and Real Estate Development, represented by Engineer Ayman Kamil Al-Najjar. Sharia Dar, represented by Ahmar Ahmed, the Executive Manager. Also, we honor and recognize the members of trustees, the new members of trustees, the Dubai International Market, represented by Mr. Ahmed Al-Zaabi. Partners who signed memorandum of understanding and collaboration, Ms. Datok Almana Chogar, the Executive Director of the Center. The center recognizes the Asian Center for Reconciliation and Arbitration and the recognition received by Mr. Rami Suleiman. Lastly, the center thanks and appreciates the team that organized this event, Ms. Maria Kamal Mals. Miss Kali Jean Dawood. Miss Amira Auda. Mr. Mahmoud Mohammed Nader Faqir. Thanks to our participants and our partners for their work. Ladies and gentlemen, we invite you to attend the exhibition and to have a break for 15 minutes. Then we will have the first session under the title, The Islamic Model for the Construction Sector. Thank you very much. This is a book giving to the Minister of Justice. Thank you.
Mic check 1, 2, 3. Mic check. Okay. Mic check 1, 2, 3. Mic check.
الحضور الكريم، ندعوكم الآن للبدء في أولى جلساتنا لهذا المؤتمر، فلتتفضلوا مشكورين.
Take your seats. In the name of Allah, the most compassionate, the most merciful, praising to Allah and praise to Allah who helped us and guided us. Peace be upon the Prophet Muhammad and his followers. Your Excellencies, Your Highness, ladies and gentlemen, I'd like to welcome you again in this magnificent conference about launching the model for launching the Islamic-based construction contract under the slogan Based Clauses and Innovative Methods of ADR, which establishes a new stage of developing the Islamic contract for the construction sector that is aligned with the Sharia, Islamic Sharia. It's our pleasure to start this session under the slogan, the model Islamic contract model for the reality and ambition, chaired and moderated by Muhammad Mahmoud Al-Kamali, the chairman of the training institution, and he has a long career in the justice system. He also held many positions as a trainer and as a judge in the UAE. And this session, we have panelists on like Engineer Kamal Nas, the head of the committee of drafting the contract, and Mr. Robert Minsky, a moderator and arbitrator, Engineer Arena, the manager of the demands and commands from HKA. Ladies and gentlemen, our panelists, the floor is yours. In the name of Allah, the most compassionate, the most merciful, praise to our Prophet Muhammad, and peace be upon our Prophet. At the outset, I'd like to thank the organizers for inviting me to be part of this event, particularly in this first session with scientists, experts in the domain of contract and construction. As you know, the Islamic contract is a model, is a framework, a new framework that aims to regulate the contractual relationships in the construction sector in line with the Islamic Sharia, taking into account the legal and the legislative frameworks. And it also relies on the jurisprudence, Islamic jurisprudence, like avoiding ignorance, and with a framework that is aligned with the civil laws and legislations. Today's topic, it comes at a time that UAE is witnessing, the Arab world also, witnessing accelerated rate in terms of developing the legislative frameworks and embracing Islamic contracts that could achieve or strike balance between Islamic Sharia and the requirements of the work environment. And those contracts contribute to establish a very robust construction sector, and also a sector that is fair, just, and transparent, particularly after the issuance of the construction, the new law in the UAE that emphasizes about the commercial contracts. It's my absolute pleasure to moderate this session, and I have on board experts who will enrich our knowledge, and we will touch on 3 valuable papers. We start with the first speaker, Engineer Kamal Adnan Malas. Dr. Kamal, as everybody knows him. He needs no introduction. He holds PhD in alternative methods of arbitration, and he holds excellence in engineering. He has done arbitration over 1,200 cases, and in constructions and other domains. In the arbitration contracts, so he looked at 1,200 cases pertaining to arbitration, and he's an expert and an arbiter. He has he looked at 130 international cases, local and regional cases about arbitration. The amounts of those cases were enormous, because those cases had enormous amount, like exceeds $2 billion. They went to him because he's an expert. This is a nutshell about his expertise and background. So he has a long journey. He has a long CV. Doctor will talk about why we launched this model in 2021. So the floor is yours. You have 15 minutes. In the name of Allah, and peace be upon the Prophet Muhammad. It's my pleasure to be with you here today, among experts and scientists and arbiters and lawyers and advocates here in this room. Thanks for coming. And I would like you to share with us your views about this contract. This vision, this edition that we have launched, we could say, it's the beta version. It means 180 page. After we have your feedback, we can modify it. We can add it or omit based on your feedback, and we'll definitely update this edition next year in 2026 and then in the year after. So this edition is open to update and modification. It will be updated on regular basis, on annual basis. So whenever we have new legislations, frameworks, whenever we have new laws, we would amend or change or edit or update this contract. It's not static by any stretch of the imagination. This contract is flexible and subject to update. This contract, what really motivated us to come up with this model, with this contract, is, honestly, it's an old concept. At our center, Islamic Arbitration Center, my brother, Dr. Sulaiman, told me that for a long time we were considering this idea to be materialized. So I told them I'm ready. So the center came up with a committee of 24 people for drafting and editing. So we communicated with other experts, and we drafted this contract that consists of 180 pages. This contract resolves conflicts. In other words, when we were drafting this contract, we considered that whenever we have a dispute, we need to resolve. The idea is not to resolve issues, but to look at disputes and come up with a solution for any potential disputes, so that the idea is to resolve disputes. The other idea, the solution should be aligned and compatible with the law. And the other point, this law does not conflict or contradict with the Islamic Sharia. So this contract is aligned with the civil law, is aligned with the Islamic Sharia, and also aligned with resolving disputes. So it won't be a source of dispute, and actually it will be a source to resolving disputes. This is what distinguishes this contract from other contracts. So the drafting was very gradual, and our experts will tell us how they managed to draft it in a way that helps and paves the way for resolving disputes. So this contract will never be a source of dispute. On the contrary, this contract will resolve any potential contracts between parties. So this contract has one version, can be utilized, and it can be used with a big project, big construction contract, and it can be also used in a very small project. So this contract could be applied in a large scale, in a large projects, in a small project. It's accessible, easy, can easily be interpreted. So the contract also refers people to the civil law, and the law helps us. The contract is based on the civil law. So we may have variations, we may have additions. We tried to come up with this in a way, we tried to draft this contract in a way that does not contradict the civil law. So the engineer knows everything from a legal perspective, because I play a role as a member of committee or a member of board in so many universities. I trained and taught in so many universities. I know how to help engineers to graduate from universities. Now, many engineers lack the legal background. I know many engineers, when they graduate, they lack legal background. Therefore, this easy, accessible contract will help new engineers to understand the legal ramifications of the projects. Because an engineer goes to work, but he doesn't know how to draft a letter in a legal sense, and that mistake in that letter could cause millions of dollars. So this easy and accessible contract can help engineers to understand the legal frameworks, and will help engineers to draft letters in a way that does not harm the companies or any parties. So we have we have so many elements and variables in the contracts. The general conditions in the contracts are there, and they can be looked at, and can be reviewed. Special conditions in the contract are drafted. There are articles or clauses that stipulate that when you have a special condition that prevails, the special conditions prevails other terms. So when we have articles, when we have any articles that contradicts the special conditions, then the special condition prevails. So we don't need a court to tell us that the special condition prevails, because the contract dictates that the special condition prevails over any other terms and clauses in the contract. So thanks to Allah, we managed to come with the last meta version. We hope everyone help us, give us feedback, comments, additions to improve the text and improve the contract. We look forward for experts like yourself to give us feedback so we can improve the text and we can add any meaningful addition to the contract. Now I give the floor to my colleagues to. We may have some, so I leave my floor to my colleagues to contribute. Thank you, Doctor. Doctor touched on the challenges, the current challenges on the Islamic and contracting, and how can we overcome those challenges, and how can we make sure that those contracts are aligned with the Islamic Sharia? As you know, this contract is subject to change and improvement, and we seek your feedback to improve that contract, to reach a final draft. The contract is good, but it can be perfect with your feedback and your contribution. The second paper, the second speaker, next speaker. مؤتمر الهام عن العقود، وعندما نرى الصياغة ومسودة، هي مسودة تحاول تحاشي النزاعات والخلافات في قطاع العقارات والإنشاء. عقود الإنشاءات القائمة على الإسلام والشريعة، هناك أشياء أشرت إليها والدكتور كمال تكلم عن هذا الموضوع. التعديلات، إذا نريد أن إجراء أي تعديلات يجب أن تكتب في العقد وليس في نص مختلف أو في نص جانبي. فالإضافات والتعديلات تصاغ وتكتب في العقد نفسه، فالتعديلات تكتب على العقد أيضا. وشروط الخاصة وهي نادرة في العقود يجب أن توضع في العقد وتصاغ في العقد، ولا تصاغ في ورقة منفصلة لضمان أن العقود مفهومة وهو عقد واحد. فنبحث في 3 أو 4 أماكن للوصول إلى بنود العقد لنرى إذا تم تعديلها. هذا نقطة هامة. العقد نفسه كما أشار الدكتور كمال 180 صفحة، وهو كثير من الصفحات. إذا قارنا ذلك بالعقود العالمية الأخرى ليس نفس الشيء، لأن العقود يجب أن يتعامل مع كل جانب من جوانب قد تواجه تحديات أو إجراءات تتطلب من عملية التشغيل. إذا نظرنا إذا في العقد لن أخوض في البنود ستأخذنا اليوم كامل، ولكن سأقوم بالتعريج على بعض البنود. أول قسم، أول جزء بتقديم العقد، وتقديم العقد يضع القضايا العادية: السعر، الكلفة، زمن الإكمال، المبالغ المحفوظة. هذه شيء طبيعي، هذه منسقة مع باقي العقود في قطاع الإنشاءات. والعقد يتكلم عن التأخير وضرر التأخير وزمن التأخير المسموح به هو 10%، وقياس وحدة القياس التي يتم الاستعانة بها، والنسب التي يتم إضافتها، والكلفة الإضافية. هذه أشياء يتم إضافتها. الكلفة الإجمالية للدفعات الأولى، هذه دفعات مقدمة تسمح للمقاول للبدء في العمل ويكون لديه تدفقات نقدية. من المهم أيضا العملة والدفعة الأولى. العملات لا تكون عملة واحدة، تكون أكثر من عملة. ونسبة كيف يتم دفع الدفعة الأولى؟ هل يتم دفعها بنسبة من الكلفة الكاملة؟ هذه هي قضايا مرتبطة ومباشرة في قطاع الإنشاءات والعقارات. هناك أيضا كلفة التمويل إذا كان هناك تأخير في الدفعات، وقائمة على النسب المتوسطة في مستوى معدل الإقراض البنكي، وأيضا الكلفات إذا كلفة التمويل أو لا توجد هنا ربا، لا توجد هنا الربا، فائدة، ساعات العمل، التأخير والضرر على التأخير لكل يوم من أيام التأخير. فتتكلم عن ما العذر من وراء التأخير. كلفة التأخير أكبر، وكلفة التأخير والضرر من التأخير يجب إشارة إليه في العقد، وهذا أيضا قابل للتفاوض. وأيضا سيتكلم عن المستشارين الهندسيين لإدارة العقد. هذه عملية واضحة المعالم. التعريف ليس كباقي العقود. هنا نرى تعاريف مختلفة، والتعريف يعطيك خلاصة العقد وفكرة العقد. فمن الخطأ أن نتجاوز أو أن لا نقرأ تلك التعريفات، فيجب أن نقرأ التعريفات الموجودة في العقد لأنها تعطينا نبذة وزبدة وخلاصة العقد. بعض التعريفات، العقد نفسه يعرف العقد. فما هو العقد؟ العقد قيمة العقد، رسالة القبول، رسالة النية، وأطراف العقد. هذه الظروف، الشروط والمواصفات، جدول تقديم العرض، وأي وثائق أخرى يتم إرفاقها مع العقد. ومرة أخرى في العقد كل شيء نحتاجه بما فيها الأوراق الإضافية والوثائق الوظائفية، وهذا يجنبنا النزاعات والخلافات وسوء الفهم، وهذه نقاط هامة. إذا كان العقد يكون قائما على الكلفة فيعطينا معدل الكلفة ونسبة الكلفة، لا يوجد شك أن يتم تعديل هذه الكلفة إذا دعت الحاجة لذلك، ويتعامل العقد بالنزاعات. وهناك مجلس لحل النزاعات. هناك فروق. سأقرأ بعض تلك البنود. المجلس مكون من 3 أشخاص يتم تعيينه من قبل المشغل أو الشركة، وشخص يتم تعيينه من قبل المقاول من عمله، ورئيس مجلس فض النزاعات يتم تعيينه من قبل المجلس الإسلامي لفض النزاعات. فلدينا عضوين، عضو من الجانب المقاول والآخر من جانب الشركة أو المالك العام المشروع، ورئيس لجنة فض النزاعات هو من مركز فض النزاعات. هذا للحفاظ على استقلالية مجلس فض النزاعات. ولا يمكن أن يكون لدينا مجلس لفض النزاعات والمكون من الشركة أو صاحب المشروع أو المقاول. هذا لن يعمل. فمجلس فض النزاعات يجب أن يمثل كافة الأطراف. فبطبيعة الحال كل طرف سيمثل جانبه. فلدينا مجلس مكون من مجلس من فض النزاعات يكون من جانب مالك المشروع ومن المقاول وأيضا من مركز فض النزاعات. فلدينا هذا التمثيل لثلاث الأطراف، والرئيس والمحكم يقود مجلس فض النزاعات لضمان نزاهة وحيادية واستقلالية مجلس فض النزاعات. والفكرة أن التمثيل ما بين كلا الجانبين لضمان أن مالك المشروع يتم تمثيله والمقاول يتم تمثيله في مجلس فض النزاعات. فهذه الفكرة، هو أن نمثل الأطراف في مجلس فض النزاعات. كل عضو من أعضاء مجلس النزاعات سيمثل طرف من أطراف التعاقد.
والاتفاقيات الموجودة في العقد أيضا تحاول أن تستهدف التوازن بين الأطراف. التوازن تعني الكثير في الحقيقة، كما ذكر الدكتور كمال في الكلمة السابقة في تقديم هذا العقد، وهذا ما يحاول العقد أن يعمله. يحاول أن يحقق التوازن بين المقاول وبين أطراف العقد ليرى أن العقد خالي من كثير من المشاكل بدون أي نزاعات. كذلك الطريقة المثلى لهذه العقود التعاقدية في مجال التعاقد هي عقود تستهدف مشاريعا مصممتان، وكذلك تستمر عندما يستمر المشروع في العمل قدر الإمكان، ولديه التفاصيل الكثير جدا. يجب أن يكون العقد يحتوي على التفاصيل الدقيقة أيضا. هذه العقود تحاول أن تأخذ ذلك بعين الاعتبار عند حل النزاعات بحيث يحدث التوازن بين أطراف العقد لتجنب النزاعات. علينا أن نقول أن هذه العقود تقريبا ليست واضحة 100% بذاتها فيما يتعلق بكلفة العقد، أو لديها الكلفة الزائدة من الفوائد فيما يتعلق بالأشياء التي يمكن أن نقوم بها، مثل دكتور شيرهيل، وهي طبعا مختصة في هذا المجال. لذلك اعذريني عن ذلك، لا أريد أن أعلق على ذلك. لكن التعويضات المتأخرة بالنسبة كنت متأخرة بطريقة معتادة أو طريقة عادية، وفي ظل هذا العقد أو بموجب هذا العقد تحدث تقريبا 10% من الأعمال المنفذة. إذن التأخر في في تنفيذ العقد غير محدد في العقد. المنازعات في العقد أيضا هي طريقة كيف يمكن أن تحصل هذه النزاعات. هناك خطوات يجب اتخاذها قبل أن تتفاقم هذه النزاعات بين الأطراف، ومن ثم رفع هذه المنازعات إلى مجلس فض المنازعات مرة أخرى. يجب أن يكون من الواضح أيضا كتابتها ربما هناك بعض الاختلافات أيضا في الترجمات غير دقيقة، لكن النسخة الإنجليزية واضحة جدا، والتأخر وكيف معالجة هذه التأخرات أيضا والإنذارات أو الاختيارات أيضا يجب أن تؤخذ بعين الاعتبار في العقود أيضا. كل هذه القضايا أيضا والأشياء المتوقعة أيضا في العقود يجب أن تكون محددة وتبين تفاصيل العقد أيضا. إذا كان لك جي في أيضا لك مشروع مؤسس مثلا، من هو المتعاقد أو المقاول، ومن ثم نأتي إلى أشياء ربما لست متأكدا 100% منها. ما إذا كان لديك فقرة مثلا 1.6 حول الموظفين، ما إذا كان غير مهندس مثلا أو كان لديه أيضا وصول إلى الموظفين، إذا هناك شخص منفصل من المهندسين يمثل نيابة عن صاحب العمل، ويجب أن يكون هذا الممثل في العقد الثاني 1.7. هناك طبعا ممثلين أيضا للموظفين، وهو الشخص في المجلس أيضا الذي لديه صلاحية من صاحب العمل ليمثله في اتخاذ القرارات، وكذلك القضايا أيضا المؤخذة بعين الاعتبار من قبل صاحب العمل. إذن هذا شيء جميل. ومرة أخرى ربما هناك خطأ في الترجمة في العقود أحيانا، وأود أن أوضح هذا فقط شخصيا قبل أن تذهب إلى أن ندخل في هذه العقود أو نبرم هذه الصفقات في العقود. إذن هذا العقد مثلا والاختيارات أيضا الذي يجب أن نأخذ بعين الاعتبار، ويجب أن تكون الأمور واضحة أيضا، وأيضا يجب أن تكون واضحة أيضا بالنسخة العربية. لكن هكذا يجب أن تكون صيغة العقود الإنشاءات. تقديم الوقت طبعا أيضا أو تأخير الوقت أيضا شيء مهم آخر، ومرة أخرى أيضا والاختيارات أيضا يجب أن نضعها أيضا كيف نطبقها مثلا أو كيف نمدد الوقت. ومن المهم ذلك أيضا أن هذه الوثيقة يجب أن تقدم أيضا إلى كالعادة نتمنى أن يكون لدينا وقت أكثر لنتحدث الكثير عن العقود، لكنني أشكركم على هذه الفرصة للحديث عن هذه العقود. شكرا مرة أخرى. Needs maybe 2 or 3 days to talk about that, but we are committed to time. Mr. Robert talked to the model Islamic contract for the construction IBCC 2025 from the construction or the content and the drafting stages and adopting it, and he highlighted the most important features and characteristics of the contract internationally and regionally, and he also participated in preparing this contract. And this contract is important and new for the construction sector, and it needs a lot of time because there are some notices from other people, but it shows that it is good work and burden work adopted by the center. The third speaker or the في العقود.
As Robert said, have fair allocation of risk, doesn't have gaps, doesn't create ambiguity, and thereby, reduces the ground for potential claims and disputes. And what's the impact of this? I think it's quite obvious to say less contentious environment in the industry, which is good for everyone. We spend less time and cost on arguing our positions, claims and differences. And
فروق في ذلك. وبشكل عام إذا نظرنا من وجهة نظر الاستثمارات العالمية، فللمستثمرين يجب أن يكون لديهم ثقة أكبر في هذه الأسواق، وهذه الأسواق عادلة ولكل شخص، لكل اللاعبين والمؤثرين التجاريين. كما ذكر سيد روبرت، هناك موضوع
seen all word collaboration, collaboratively, consultation used quite a few times. And it just gives you the flavor as to how, what was in mind, when the contract was drafted, and for all the parties to come together and instead of being confrontational necessarily, you aim to consult, you aim to collaborate and to avoid, contentious environment leading to costly disputes. The introduction of the modern DAB is a welcome development. It's a multi-tier dispute resolution clause. And as I said, the first step is consultation, which I think is very important. And then there is a separate provision for avoidance of disputes. And even the language itself just tells you that the aim is to avoid, to prevent issues, to serve everyone, to keep the relationship going between the commercial parties, and to simply spend less time and cost on expensive litigation or arbitration. There is obviously an amicable settlement provision as well, which I think is also very important. So again, provides the parties with the contractual ground for resolving their disputes amicably. But I wanted to touch upon some of the provisions that I think Robert didn't quite reach to in his 15 minutes. So finance charges for delayed payment, he did mention, I agree, totally agree with that. One of the pain points we often see with claims and disputes when contractor is putting together an extension of time claim, the first starting point is, what is the approved baseline program? And we start going back and forth through the correspondence. What is the approved one, or that hasn't been approved, or maybe this one, and it goes back and forth. And I think there is the GCC 1.56 and 18.3 that deal precisely with that. So you obviously close the gap before it even happens. And something that Robert was trying to mention, and there is several provisions, I will not read through all of them, but they do provide the contractor for a contractual avenue to claim for both extension of time and cost. Of course, given that there is plausible, causation and the grounds for that, but I've seen quite a few contracts where normally there will be a provision for extension of time, but not necessarily for the associated costs, indirect time-related, or we call them prolongation costs. And that creates a vacuum, because the contractor, where there is excusable and compensable time is found, of course will try to claim for the associated costs. But if you have a gap and simply the contract is silent, that will create a vacuum, thereby obviously leading to confrontation between the parties. Notices, again, Robert did mention that, I wholeheartedly agree. It's a massive pay point, as I said, and it's good to see that this contract deals with that. It does not, let's say, it does ask the contractor to serve a notice, which is fair enough, but it does not necessarily say that if the notice was not contemporaneously served, the contractor will be completely stripped of what otherwise could have been a potential legitimate entitlement to claim. The other points that I thought were quite good additions is variations. Again, what we see in practice oftentimes is, of course, variation provision is there, talks about cost, that's fine, but rarely does it talk about the associated time impact, which I think is very important, particularly where you have numerous variations. Sometimes there are significant variations to the contract, and the sort of compound impact of those variations can be very significant on the program. So that's also a welcome addition. The other point, which I think what we discussed yesterday, is change in law. Mostly the contracts that I've seen would provide the contractor with an opportunity to claim for time, so they relieve of liquidated damages, but not necessarily the cost. And this contract does provide for that. And the last one is the delayed payments. Again, often seen pain point where the contractors would go on claim for delayed payments. And, you know, whether or not actually it does provide the ground, and if it does, wouldn't they be entitled to also claim the associated costs? And I think, again, GCC 25.6.1 deals precisely with that, which again is a welcome addition and closes the gaps that we often see in contracts in practice. I'm not sure if I still have the time. Okay, so very quickly then on the smart contracts. I did say very frankly and honestly to Dr. Kamal, look, I haven't seen yet a smart contract being implemented and which we are all very excited about, like all the other technology, new tools and digital tools, etc. But I think it's early stages, and with this contract, I think it does have good future. We are laying obviously the foundation now. The foundation looks great, and you know, with obviously some of the amendments that Robert was also mentioned that maybe will be still implemented. Yes, the potential is clearly there. Thank you very much.
Thank you, Dr. Irina Ekwelinga. And she touched on the impact of the Islamic construction contract, IBCC 2025, regionally and internationally. And she oversight the future, particularly in the Islamic and Arab countries. And this contract will be a cause to attract investments for the country, because there are many entities can adopt the Islamic transactions in this connection. She also touched on many matters in the contract regarding the delay damages and fines and other details in the contract. I would like to thank all the speakers and panelists here, and this model aims to unify the contractual drafts that minimizes disputes and enhances trust among the parties, and affords a reference can be adopted in the government and private projects that align with the vision of the country to develop the projects with a Islamic reference that contribute to the sustainable development. Thank you so much, and I would like to thank again the panelists, and thank you again for your listening. Thank you so much. We would like to open the question and answer for 7 minutes only, please. If you have any questions, you can raise your hand. Ladies and gentlemen, esteemed guests, we can take only 2 or 3 questions because we are short of time. Peace be upon you, Ahmed Rajub, legal consultant and interested in the Islamic financial transactions. First of all, I would like to thank you, thank all the participants and the speakers who enriched us with this information. My question for Dr. Kamal regarding when the contract will be available in the public to use and to go back to it as a reference. And you said that there are certain private conditions and public conditions. The private is the legal foundation, but the contract, does it include basic conditions that should not be violated? Particularly, the contract is related to the Islamic Sharia. And the other question for Dr. Robert, as an expert, international expert, you gather between the Islamic countries and non-Islamic countries. What is your perspective? Do you advise using this contract to be an alternative for FIDIC contracts and construction contracts in the projects, either international or local? Thank you so much. Thanks for the question. Regarding the contract, when we talk about the private and public conditions, and whether there are private conditions that do not conflict with the public contracts. First of all, the contract is optional for the one who wants to use it. And if one wants to use it in a non-Islamic country, he can. Therefore, he can. The book is one book. It's the same. It has a basic part, which is the conditions, the general conditions, and in the end, we put a place for the private conditions. And we wrote at the beginning that these private conditions are more important than the public. If you want to have one private condition, it can be applied. My question is, the conditions, basic conditions are important that should not be conflicted, should not be violated. Particularly the contract is related to the Islamic Sharia. We are talking if the contract is applied in a non-Islamic country. You can use it. We cannot confine the contract. We are not obligators to take this contract as it is. And in the countries that apply the public contracts can use it. We cannot oblige anyone to use the public contract. Any country can delete the public condition and put an alternative. Or you can delete it or write below it. This is one of the features of the contract. If it also includes the profit, if the profit is applied in the country where the contract is applied, they are free to go against the Islamic Sharia. It is not a forcible thing. It is an optional. If anyone wants to apply it, he is free. It's his option. Otherwise, there is no problem.
Anywhere in the world. I mean, it's aimed at the Islamic world, yes, but it can be used anywhere in the world, the way it's been written. And you have the special conditions at the end, which can be amended as necessary or added to as necessary for the non-Islamic countries. And I think reading this contract is a contract that lends itself to construction, certainly in the Islamic world, and arguably in other parts of the world. Now, of course, it's up to people, the employers, the contractors, if they take this contract up, of course. But I would recommend this contract to anybody who wishes to undertake a construction project from small to large, to consider it and look at the way this contract works, which means, really considering the contract, and recognising that this contract is a contract that is trying to create an even playing field for both parties. You look at the FIDIC contract that's used in most of the GCC world, and if you use the FIDIC contract as written, it's quite a good contract. But the employer, predominantly, will amend the contract so that it becomes, dare I say it, biased in the employer's favour. And this contract is trying to avoid that. So it's a good contract. I would recommend it. Undoubtedly, there'll be changes to the contract as it gets into use or comments are made. I would wholeheartedly recommend it.
أستاذ أحمد بهجت.
طيب شكرا. أنا مهندس أحمد بهجت خبير تقنية معلومات ومحكم. بداية طبعا بشكر المركز.
I'd like to thank the center for the enormous effort in establishing this contract. I have 3 points. The first point, first of all, I agree with Dr. Rahman. I hope that you can share with us a copy of this contract so we can share it with public and and arbitrators to look at this contract and to give you some feedback about it and to use it later on with the construction company. The second point, I agree with Ms. Arena about smart contract and blockchain technology, because today the smart buildings, all construction building encompasses the IT technology, and technology should be included in this contract. And I hope next year we will have a new version that includes technology and state-of-the-art technology. The third point, Dr. Kamal, what are the provisions and clauses that they are not compatible with the Islam that is covered by the contract now, and which they are compatible with the Islamic laws? In the name of Allah, at the outset, thank you. Thank Ahmed for your question. We didn't take one single contract and we looked at the provisions and the clauses, but in principle, this contract doesn't include overriding anyone's rights. Doesn't include. So, if I make a mistake, if I don't send a letter or a notice within 40 yom, I will not lose my rights. So the second point is the interest and how to apply interest. I'm not talking about FIDEL, about other contracts that is applied worldwide. You could see those contracts contradict with the Islamic Sharia. It overrides the rights. So some of those contracts may contradict the civil law. So amending those contradiction in the special terms, this is giving to the arbiters or the courts to look at. But we don't need this to escalate to the court and the prosecutor to resolve the issue. So we try to resolve issues beforehand through establishing clause and articles that is a contract that is balanced, that doesn't contradict the law, civil law. We didn't take from other contracts. We drafted a brand new contracts. We took into account disputes, and we drafted contracts in a way that avoids any potential disputes. About distributing and sharing the contracts, now Dr. Rami will see how we can distribute or share those versions. We will have your feedback. Obviously every year we'll have a new update for this contract. The last question, please. Greetings to you all. Thank you to the panelists. My name is Hassan. I'm a lawyer and an arbitrator in construction from Bahrain. My question pertaining to the difficulties that is faced by arbiters with regard to evaluating and assessing the compensation or the cost of delay, for the cost of delay or the time extension with regard to the contractor and the employer. It's resolved. They can have a daily compensation, or they have a limit 10%. However, with the contractor, the contractor is lost. The arbiter is lost, doesn't know how to determine their daily compensation for the delay. There is no specific or established formulate, which is, I think, as far as I know, 3 formula, HE, Leicester, and London. And also, there are very different evaluation. There are differences between those assessment. So the arbiter gets lost. I mean, it's very confusing to what mechanism it has to rely on. So this is my question. So have you taken that into account? Have you taken that into account? This model looks great, and indeed it's great. But have you taken into account how to resolve this issue, the daily compensation for the contractor in case of delay? Kindly raise your hand. Hello, everyone. This is Fatima, a consultant and a supervisor from Egyptian Bank in Khartoum. My question, if we talk about an international model for construction, what is the relationship between this contract with the FIDICAL that represent a legal framework that includes everything pertaining to the construction? This contract is a parallel to the FIDIC? What's the relationship between your model and the FIDIC? Is it a parallel contract or an alternative? What is it? Thank you for both questions. I will answer both questions. First, arbitration and compensation for the contract and using formula and MDEN. Those formulas, they are for the head office cost. The compensation for the contractor is based BQ or the real compensation. Therefore, each is based on the merits. So each case has its own merits. Therefore, we cannot establish a formula that applies to all firms. However, there is compensation that a contractor should be compensated. The method by which it gets compensated depends on the circumstances, depends on the terms and conditions. And those formulas, the expert and the arbiter decides whether those formulas can be applied or not. Therefore, it's not general, it's a special condition. With regard to this contract with the FIDIC, a relationship between FIDIC, there are many contracts worldwide, ICA, FIDIC, and so on and so forth. The most common is FIDIC. The FIDIC, those contracts, they are based on the general law, and they are based on general law. FIDIC is based on ICA. I'm the editor of the Yellow Book in 2017. So we don't criticize FIDIC because it has its own applications. This model has its own application. It's specialized in the countries that apply civil law, like UAE, Egypt, France, Saudi Arabia. Those countries apply civil law. So this contract is can work in those countries. Even if there is a country that only applies Sharia only, and this model can work. And if there is a country that has hybrid, like Saudi, that has the civil law and the Sharia, this model can work. So even in Egypt combines both. Egypt has this hybrid. It has the civil and Sharia. So all those countries can use this model. It's not a matter of a race between both models, between FIDIC and it's a question of jurisdiction. So it's an optional. If you're in the UK, in Inglaterra, you can use the civil law. In the Saudi Arabia, the law or the contracts that is closer to the Sharia. It's about the circumstance, and it's about the better choice. So now we have another source, another contract to the the center deserves some credit, so deserves some credit.
We're not criticizing FIDIC here. I think I speak for myself. It's where standard contracts are being heavily modified and create a lot of disbalanced risk allocation and gaps. That creates issues, that creates confrontation. And bespoke contracts, where often it's unfair, one-sided, all of these things, they are there. So I think with this form is obviously we're trying to tackle these sort of issues from happening. To answer Hassan's question also, as someone who is actually drafting claims for contractors and defending claims from contractors, when it comes to time-related, or we call them prolongation costs, if you think about it, it is a claim for loss. And with any claim for loss, you ought to have proved normally actual loss. So you actually have to demonstrate what you actually lost on site in terms of your site running expenses, your overheads, etc. However, if the parties agree to use BOQ rates for calculating that, I think that's up to commercial entities. So that's just on that point in terms of the costs. Thank you.
مرة أخرى نشكر الجميع، نشكر متحدث.
Our panelists in this session. I hope it has been beneficial for everyone, and it has been very educational and fruitful discussion. Thank you very much. Ladies and gentlemen, allow us to presume and continue our conference. On the second session, the impediments of construction. Ladies and gentlemen, and now honoring the panelists. We invite Dr. Jasim Ali Salim al-Shamsi, the head of the Board of Islamic Center for Arbitration and Reconciliation, kindly come to the stage to honor the panelists. Consultant Dr. Mohammed Mahmoud Kamali, the General Manager of the Judicial Training Institute in Ministry of Justice. Engineer Dr. Kamal, the head of the committee of drafting the constructing contract. Ustad Robert, the arbiter, an international arbiter. Engineer Irina Kolinka, the head of the construction requests in HAK. Ladies and gentlemen, allow us to continue our conference for the international model of Islamic-based construction contract under the slogan based clauses and innovative methods for the dispute resolution. The second session is the impediments in the contracting sector and the role of the model Islamic-based construction contract. This session comes in line with the previous sessions where it presents new visions and new ideas about the Islamic contract model. Today, we talk about the application aspect that deals with the current challenges that face the contracts and how can this Islamic model deal with those challenges. It's our absolute pleasure. This session is moderated by Ahmed Rashid Aswedi, the founder, general manager of Aswedi in the UAE. And he is an expert in arbitration and resolving disputes, and he has a wide range of experience in the oil law and commercial law and real estate law and banking law, and he holds master's degree in law from Boston University, and he has been assigned as an arbiter in over 200 cases. And the arbitration is shared by panelists to share Dr. Engineer Ayman Kamil Najjar, Dr. Engineer Bashir Samha, Professor Abdulrahim Sapuni. We look forward to have a very rich and technical discussion that combines legal aspect and technical aspect. We are looking forward to have a very fruitful discussion. Greetings to you all. In the name of Allah, the most compassionate, the most merciful. We blame the previous session, they took half our time. So what we are going to do, the previous panelists took half our time, and our audience wants to eat, wants to have lunch. So we are between you and your lunch, so allow us. We will try to be as brief as possible. We'll try to expedite the discussion so to wrap up so you can enjoy your lunch break. At the outset, I'd like to thank the organizers for inviting me. Second, I'd like to thank the people who drafted this model. I think it's the start of liberating ourselves from the traditional contracts who have been imposed on us from outside. This model will be launched here from Dubai to the world. So this model can be applied, even in the West, can be applied in European countries. And the point I'd like to make, the Islamic funding, the Islamic transactions, Islamic financial transactions, as economy, the Islamic economy is growing, and it's now we have it in In countries, the Islamic economy is in non-Islamic countries, like in UK. So Islamic economy is growing. That it is now you find it in the UK and US, and you have Sharia compliance agreements. So I would like to work in compliance with Islamic law. On that basis, we can come up with a model, and this model can be approved in non-Islamic countries and other countries like Arab countries and Malaysia. I had hoped is naming instead of Islamic-based to Sharia compliance instead of Islamic-based. So it's international model for Islamic-based. I think we need to change the name to amend it to be aligned with Arabic translation. International model for Sharia compliance construction contract. Doctor, you know better than me with regard to naming and translation. To draw your interest and your attention, as a committee, we will have slides. We will use the slides to keep you interested in our talk, unlike other speakers. I'm sorry for taking too long, but I needed to praise those people who exerted this enormous effort in drafting this contract. Our colleagues, our panelists, very good doctors, very good experience. They don't have only an academic experience, they do have also a practical experience. They are not only consultants or supervisors, they are developers. They deal with those contracts, and they are employers and developers at the same time. So they enjoy these two aspects of experience, and they deal with those issues on a daily basis. So they also have a rich experience in the construction sector. So giving the limited time, we will talk about the impediments of the construction sector and the impact of the Islamic model in enhancing those or overcoming those challenges. This is very crucial because most of the troubles that we have with regard to the construction contract, sometimes the contractor would tell you, the contractor would propose anything to win the project, and when the contractor wins the bidding, then he comes up with variation to gain more and more money, and then the employer would also wants to also mistreat the contractor. I've never seen a poor contractor, but anyway, our topic is, I need to introduce our panelists. On my right, Dr. Engineer Ayman al-Najjar, the General Secretary of the Trustees of Harmony Art for the Engineering Consultancy in the UAE and Syria. Dr. Ayman is an expert and an arbiter in the UAE and worked and covered many cases pertaining to arbitration, whether in Ajman or Sharjah or in Dubai, and he is accredited arbiter by the centers and by courts. He has 29 years experience in this domain, and certainly he will benefit us by sharing his expertise with us about the interment payments or temporary payments. And Mr. Dr. Engineer Bashar Taysir Samha. Engineer Bashar Taysir Samha. He is an engineer and a doctor. At the same time, he is a developer in the UAE, in Syria also. He is a graduate in 1982 from from Albo University in civil engineering, and he holds a PhD in engineering from Yerevan, in construction from Armenia. He holds engineer degree from the Syrian. He holds FIDIC certificate from Damascus in 2010. Obviously, he has a huge experience in engineering and contracting, and he worked on development, and he is a manager of many companies. So he does have experience in this sector. He is the chairman of the board of a contracting company in UAE, and he worked as a contractor in Dubai and Sharjah and Ajman. He covered project of 300 million US dollar, and he is the chairman board of Samha company in the UAE, and he has 5 towers in Dubai, and he is the manager of Amisa in Sharjah, and he has so many residential buildings, and he's a partner in 80% percentage in Amisa investment and real estate development. His Amisa company invests in real estate in 4 domains: residential, medical, tourism, and industrial. And they have a bunch of investments in different domains, and he is a shareholder in this big company. With regard to tourism, the company, Amisa company, has a bunch of Amisa. What Amisa means, I don't know what Amisa means, but it seems to be a construction. Amisa means it's an Assyrian word. Means what it means? It's an Assyrian word. Sorry, the interpreter cannot hear the speaker. Thanks, doctor. In addition to that, he is a member of many committees and that is pertaining to engineering. And also on my right, Professor Abdurrahim Sabuni, the academic consultant for the UAE researchers, and he is the executive director of the Spine for the Investment. Professor in construction engineering and the dean of university, and he enjoys a wide range of experience in arbitration and AI. Holds PhD in construction from Cornell and master degree in George Washington University and bachelor degree in engineering from Damascus University. In addition to technical certificates, he is an independent arbiter from 2013. He worked for so many institutions, and he is a member IICRA in the UAE, a special engineer and accredited engineer. He held senior position as an engineer, as a designer of projects in Abu Dhabi. Played a role in big engineering companies, in addition to establishing and developing a bunch of universities in the UAE and abroad, and a member of many trustees committees like Afro-ASEAN for AI and cybersecurity. I have always problem pronouncing this word. And he worked for the UAE Research Center, holds many awards. He won many awards from Cornell University in 20. He won many awards from different universities. He was named the ambassador of science and technology. During our meeting, we talked about AI and how in the UAE, in the US, in the UAE, the engineering started applying in UAE, even in resolving disputes. We are running out of time, so I start with the engineer, Dr. Ayman Najjar, to tell us about the mechanisms by which we clear the interim payment or temporary payments. Doctor, the floor is yours. Greetings to you all. The paper that I'm going to look at or talk about pertaining to the issues pertaining to interim payments or clearing the interim payments for the constructor during the execution of the project or interim payments. This issue is one of the reasons of stopping the project or seizing the project. Sometimes it could lead to the cancel of the contract. One of the challenges, the contract, the model, the Islamic model deals with those challenges through provisions and clauses, which is also aligned with the Islamic Sharia. If we look at those topics or the issues, we have four main challenges. The first one is the delay issuing the payment by the consultant. The consult takes forever to clear the payment to the constructor, and the contractor also doesn't receive the contract. In this case, the contract deals with this issue and gave 7 days for the consultant to agree with the contract about the payment.
If they do not agree with the percentages of completion and disagree with the payments, the contractor should be given 15 days to issue the payment without the agreement of the contractor. The other problem is the delay of the owner to pay the payment. Also, the Islamic contract, unified contract, tackled this issue and gave the owner 10 days to pay back the payment, or maximum 15 days as of the issue of the payment by the consultant. The third problem in this issue is the unjustified deductions. The owner sometimes deduct unjustifiably because the amounts are delayed to guarantee the delay fines. These deductions are not justified. The contract tackled this topic also. The fourth issue, which is important also, the ambiguity of the conditions of payment. The Islamic contract tackled this issue also, and the dates are explicit and clear in this topic. If we want to go over these problems, the contract, the Islamic construction Islam, based on the model, allowed the principle of amicable and consent, so that the contractual relationship will continue between the parties, and the finance will not be disrupted for the contractor, so that he will continue in his financial coverage to pay the salaries of the workers in the project. If we would like to talk about these problems, we need to talk about the clarity of payments. The time and the clarity of payments should be clear, and this Islamic contract tackled them, as we said previously. The second point is that it allows the paying by installments, and you can delay the payment or pay in installments, or according to the stages of completing the project. This is an example which is mentioned in the phrase 4.2. The payments should be identified and should be related to real completion and implicable and adopted through the stages of the project completion, and this was mentioned also in clause 1 of the contract. The also guarantee of the rights of the contractor when there is delay in the payment. The owner, if he is delayed in the payment, he will be the cause of the payment. This does not stipulate the rights that the contractor might be entitled in this case, but in the Islamic construction unified contract, the right of the contractor to indemnify if he delayed, the contractor will be exposed to financial damages. So there will be a condition that gives the contractor the right of indemnity if there is finance, instead of the usury profit, which is not allowed from legislation. When the payment is delayed more than the period, like for example 30 days, the contract gives the contractor the right to go to the failure or negligence side without bearing the fines of delay. And what are the losses according to the Islamic Sharia, according to the Prophet. The contract also reaffirms the disputes and the hedges also. For example, the hedges should be identified, should be shown strictly, like for example 5% or 10%, 5% for the good implementation, or 10% should be deducted from the payments in general. Of course, the contract also showed the conditions and the mechanism to disclose this hedge, 5% or 10%, after the final delivery of the project. The fines of the layment should be mentioned in the condition of penalties, provided that they will not exceed the real damages. And the contractor will be exempted from fine if there is the implementation is due to the contractor failure. This is mentioned in the clause 2.2 in the contract. What is the role of the consultant engineer in the project? He has a big role to avoid these problems that I have mentioned previously. So the consultant represents the technical reference between the owner and the contractor. The role of the consultant, the first role is he should measure and document, measure the completed works and document them regularly, and document all of them in the right place without delay. This in the clause 3.3 in the contract. For example, the issue of the payment certificate or the entitlement. And this certificate is compulsory for the owner to commit during the contractual period. And this was mentioned in the legal rules in the UAE, that the the certificate issued by the consultant, the third clause, the consultant should be biased and equity. He should behave in equity when doing and documenting the completed or the financial documentation by mentioning the details to avoid the unjustified disputes, which is mentioned in clause 3.7 in the contract. Number 4 is management of disputes, which is a new condition, and it is found in the Unified Islamic Construction Contract. The engineer represents the owner of the contract and solve the disputes of the parts as fast as possible, so as to avoid the freezing of the contract, according to the clause 3.1 of the Islamic Construction Unified Contract that we have mentioned. If we talk about the consultant engineer, this is a new point also, which is very important, mentioned in the contract. If he is he failed to commit to that and causes damages, for example, calculating the quantities and the measurement, or delayed in the payment, he will be responsible of the compensation contract for the contractor and the owner. Therefore, there is a mechanism to have interim payments, and the role of the consultant in this depends on the transparency and making sure that the contractor is entitled to the payments according to the completed works, according to the conditions and the specifications agreed upon in the contract. Thank you so much, Doctor. Doctor, I have a question. The issue of payments is the core of the problem, and the delay of the consultant to approve the payments is one of the problems also. The reason is that the consultant works with the employer or the project owner. Sometimes the project owner does not have enough money to pay for the contractor, so he will delay in the payment, and the contractor will receive payment late. What do you think as a suggestion or a proposal that the contractor, he cannot take the project unless he is sure that the project owner and has the value of the project deposited in the bank, for example. Sometimes the project owner has more than one project, and he does not enough finance to pay for the employers and the workers. So he will be delayed and will damage the contractor. What do you think that there should be a condition before approving the project? The project owner should prove that there is enough money deposited in the bank and there's bank credit in the value of the project. For example, to guarantee the stop thing, I think there is one important point. It is assumed that it should be taken into consideration, and apart from this, the freeze of the project, usually the contractor is paid. There are contractors and there are subcontractors, for example. These contractors, the subcontractors, they are supposed, in my opinion, to guarantee the continuity of the project is according to the value of the works stipulated and given to the subcontractors. The other payment should be shown in an invoice for the payment of the subcontractors. It is a chain starting from the owner when he delay the payments, entitled payments, and also the contractor and the subcontractors also. So the guarantees can solve such problems. Thank you, Doctor. Now with Dr. Bashar Tasir Samha. Dr. Bashar, what are the provisions of the Islamic contract according to the variations? According to my knowledge, Doctor, you have slides, I think. You have only 15 minutes. Peace be upon you. Allow me, before my presentation, I would like to, by the Islamic Union of Real Estate for the Islamic Economic Council, as the deputy CEO, to thank you, Your Excellencies, and the people who organize this conference, to thank you a lot. And we in the Arab Union, we appreciate your efforts to achieve this contract, which is a big shift in the construction and investment sector, regionally and internationally. And we look forward in our union to more fruitful cooperation as strategic partners. hoping that Allah may guide us. And going back to the presentation, which will take around, which is about the provisions of the changing of the construction and the additional and the changes in addition or in minus in the construction sector 2025 and the effect of that on the rights and the obligations of the parties. We say that the Islamic contract, the Model 1, regulates and which is provided by the International Center for Conciliation and Arbitration, the change of the provisions, the change in orders, either by addition or subtraction in a way that conforms with the Islamic Sharia, that prevents unclarity or negligence. In light with the provisions of the Islamic Construction Unified Contract, which is based mainly on the certain draft to guarantee the equity of the financial and agreement to avoid unclarity and negligence that nullify the contracts by changing the additional or the work in light with the Islamic contract for constructions 2025 on the basis of amicable and the allowance of addition or omission within controls that guarantee the equity of financial in order to avoid disputes of that affect the parties due to these changes. In light with these principles of the Islamic contract, we deal with the variables as follows. The orders of variation or variation orders that allow the owner or the manufacturer to amend the characteristics or the quantities or the nature of the work after the conclusion of the contract within the provisions and conditions, writing and amicable conditions. The order variable should be written and issued by the owner or the engineer, and the contractor should approve in order to avoid dispute and damages. The jurisprudential adaptation should be an annex to the original contract or a new contract that necessitates amicability upon the details, but the changes should not go beyond the nature and the scope of the contract unless there is a consent. But the unagreed works, if the contract has any additional by a consent or an allow from the contract without payment, the contract should have the same equity of the market in order not to deduct the amount for the contractor. The additional variables, when the change raises the work, the provisions will be reflected to the parties of the contract. The contract has a right to additional payment. He deserves that for this addition, identified by the previous consent about the changes or the prices of the cost in addition to the margin of profit which is agreed according to the agreement, and the contractor right also to extend the period. The contractor should be given an extension that align with the size of the additional work in order to avoid him burden. According to the commitments, he should pay the amount according to the mechanism of payment that was agreed before. The changes in the reduction of the contract, when, for example, the amount is reduced or the clause is deleted, there is a condition. The right of the owner should deduce from the total amount based on the prices of the contract for the quantum schedule or the prices also. the contractor should be indemnified due to this shortage if it is big or large that leads to damages, like for example, the loss of profit. The owner should commit to indemnify him for this damage, like for example, the cost of things that were bought before or delivered to the site, or administrative fees, in addition to part of the lost profit due to deleted works. Also, it is not allowed to delete part of the work and vest it to the contractor or another one to damage or harm the contractor. The commitments and the rights of the parties, the variables should maintain the economic and legal changes between the parties. From the owner or the manufacturer, they should commit to pay the additional agreed amount, and the contractor has the right to have the additional wage, and he should commit to invoice transparently and strict invoices. And the owner should deduce the reduced works, and the contractor, he should commit to accept this contraction from the contract, and he has the right to be indemnified from these reductions if they're a big reduction. The owner also should commit to extend the amount, and the contractor should extend in accordance with the additional work. The owner also should hold the contractor accountable for the new contracts, and the contractor also should commit to the amended and the conformed works under the contractual agreement. In a nutshell, the Islamic contract and the variables for equity and fairness, the contractor should not start with the additional works before written consent for the period and the payment, and the owner of the work should pay that in order to avoid the damage. The variable orders of addition and omission, the Islamic contract tackle them according to the jurisprudent rules that allow the amendment of the content of the contract, and they are based on the following points. The base of changing the written thing, every change should be written according to that issued and approved by the consultant engineer or the representative directly. Also, the legislation orders the contractor should not do any additional work without this written consent, because it prejudices the contract, and it deletes the ignorance of the contract. Within the limits of the power, the conditions of the contract limit the powers, and the core variables sometimes require the written consent previously from the owner of the work or the project. Pricing of the additional work are done in accordance with the chain that to avoid the dispute. If it is conforming with what has been stipulated in the schedule of the pricing and quantums, these amounts are evaluated according to the prices of the original unit stipulated in the contract. But if the works are not conforming with that, like for example, the building does not have CCTs, and the legal conditions require that to provide the building with CCTs, for example, the prices should be agreed between the contractor and the owner before implementation, showing the real cost added to the profit and the administrative burdens. When the contractor starts that without consent or agreement of the price, and he starts the work without agreement of the price, so this additional works without identifying a previous price, the contractor should have the same or what he has profited from, which indemnifies the contractor the fair profit based on the common prices in time of the implementation to avoid to enable the contractor avoid the taking money without right. The written orders issued by the contractor or the ownership represented by the consultant for the contractor during the contract implementation and amended within the scope of the work in the contract, and they conclude the additional works mentioned in the provisions. The omission or amendment is the change of the work or the materials or some types of materials. For example, the building is provided by the aluminum cladded, for example, from Al Khalil or Al Khalij aluminum. The owner wanted to change this, so the type of this will result in change of the price. So the amendment of work in this case, this clause does not need an extension of time because the clause of aluminum did not change, but the type of aluminum changed. So in this case, we need the difference in the price, either in addition or omission according to the market prices. If the clause that is changed needs, for example, a request from abroad and the contractor needs an additional time for shipment or purchase or opening an account, like for example importing the material from abroad, to guarantee the safety of the contract and to avoid the dispute, it should be documented in written. The contractor cannot omit or add anything without previous consent, written consent, unless the contract mandates the contractor without referring to the owner. So the two parties should be cognizant of the changes in amicably and freely and identify the amount which achieve the conditions and nullify the conditions of negligence. The unified contract might put a level for the addition or the omission without approval of other entities, like for example 5% or 10% of the value of the contract, which aim to protect the value of the contract, and the effect of the orders, variable orders, needs more time to implement. The contractor should have the extension, and this extension should be mentioned in the variable order in order to avoid fines. But when there is omission, the contractor should not extend if the omission is core, and this variable contract is one of the dispute orders in the construction contract, so they should be stipulated clearly, which is very important to guarantee the continuity of the project in general. The object of these provisions is to maintain the original or the authentic contract with flexibility to implement these construction projects, and the variable order should be dealt as part or not a new part, provided that they commit to the provisions to guarantee the commitment for the phrase of the clause of the amicability and friendly according to the Islamic provisions. In the name of the Arab Union for construction to adopt these model provisions because they change the variables from dispute to written and transparent and equity thing in the contractual contracts. Thank you, Doctor. I would like to confirm what you have said. The variable orders are the base of the dispute between the parties, but the project, you can see it on the paper and you imagine it, but when you look it on the ground, you will have a lot of things that are changed, and here the contractors exploit this point. We are talking to you as a contractor, Like, for example, you asking me to implement changes and they need an extension, and we have a lot of other things to implement. These changes should have a certain time or certain period if they are basic, but the agreed time between the parties is important. It is included in the process of change. The constructor should directly say that, for example, this change should clarify that. They should clarify the amount or the cost of the change, and they should agree about that previously in order to avoid the disputes between the parties. In this case, everything is paid as of, everything is expensed and paid after the variable order, and the start of the implementation of the variable things will include this change clause. For example, the next payment will include what has been implemented from the variable order itself. The parties should take this into consideration.
We shouldn't pay the value only later. Each payment is being cleared. Part of this article should be included. Thanks, Doctor. This causes issues and this creates job opportunities for lawyers. Let's keep it going, because those disputes create job opportunities for lawyers and attorneys. If we resolve all those potential issues, lawyers will run out of business. There will be no. Now we would like to talk about the force measures in the light of the Islamic model. Professor Abdurrahim, if you can elaborate on the force measures in the light of the Islamic model. Is the slide working? Are your slides working? Yeah, it seems to be the case. Thank you to our arbiters. At the outset, I'd like to thank Dr. Kamal Maghas for this opportunity, and I'd like to remind Dr. Kamal that part of the innovative ideas, he is very innovative. I don't want to praise him. I don't want to blow his head or to praise him too much, but I'd like to remind him, when we reach now, we exceed 30 years. Since the 70s, in the 70s we were classmates in Damascus University. When we graduated, we had a joint project with him. At the programmable calculator. But I would like to remind Kamal, if he can remind him, he did startup after graduation, the startup for a project in Syria. During that time, if the time had allowed, this startup could have been computer-aided education in 1979. The startup there was no angel files, So he might remember the startup he built up and founded the startup. Thank you, Doctor, for giving me this opportunity. Now, back to our presentation. I will briefly talk about it. We will talk about the first measures. We will highlight some slides. I will just briefly touch. I will highlight 3 slides only. Going back to the presentation, as an academic, as a professor, when I go back to references, the reference I go back to is unpublished. The reference IBCC 2025. I used it as a reference under publication. What I found out, when it comes to the enforced measures, they rely on standards, a specific standard, IUF 336, auditing and accounting organizations of institutions, Islamic financial institutions. I will focus on this because it has 2 parts. The part of contingencies that could be, that may not lead to the amendment of the contract, and my colleagues touched on this topic about financial aspects. I will focus on the second part, which is the contingencies or force measure that paves the way for the terminating the contract. There are different approach between FEDRIC and Islamic contract. Islamic contract, I agree with the moderator. We need to reconsider the translation instead of Islamic contract, Sharia compliance contract. So I agree with the reconsidering the translation. Practically, we need to focus on the philosophy, how to deal with this topic. The second point, how can this be compatible with Islamic Sharia? Again, the difference between both IBCC 2025 and FIDIC, as opposed to international best practices. And then the interest. If the interest is there or not, I'd like to reaffirm and re-emphasize that this contract, the contract is based on mutual agreement and subject to change. I think this contract is a very important step forward. I worked as an architect in Abu Dhabi for so many years, and I handled enormous projects, and some of those projects went through disputes and claims. The definitions, we know what it's known what we mean by force majeure. An overview about the standards, number 36 is IUFs, and it emphasizes the equity and sharing risks, and force majeure should be outside of our control to characterize it as a force majeure. And we shouldn't misuse force majeure article. For example, unexpected, so enrichment of profits. Those topics, we may have a disagreement about FIDIC and the Islamic model. This is the contract that we have launched today. It's an honor for me to take part in this event, and thanks again for your hard work, and thanks for giving me opportunity to give you feedback. I've received this yesterday, but Dr. Kamal gave me an Arabic version, and I'll go through it and thoroughly review it and give you I'll give you my feedback. You did a very good job. we focus on force majeure. With regard to theoretical foundation, the execution can be a problem. As my colleague, Dr. earlier, Dr. Bashar, he highlighted this. This type of force measure doesn't necessarily lead to terminating the contract. What really requires the termination of the contract is when the execution is impossible. Then the contract can be terminated when execution is impossible. I think those points are embedded in IBCC, and this leads to avoiding, or is a preventive, as Dr. Kamal, when I went through the contract, it's preventive. It doesn't deal with problems, it prevents the problem from occurring in the first place. The essential difference between the conventional and Islamic is the payment of the executed work, the cost of the equipment, and the compensation for the lost profit. This is very critical because I think in my practical experience, this issue is being misused. Simply put, when we cannot specify certain names or name certain people, sometimes, but an international contractor, a very well-known international contractor, he is cashing on claims. He thinks he can misuse the contract to his advantage. Therefore, we can see projects, whether private or public, this contractor has a team of lawyers and attorneys. So the contractor is using his team of lawyers to misuse those articles and generate income based in the contract. So this contractor may cause some delay, and then when there is a delay, he can claim some compensation on daily basis. It could be like $10,000 on daily basis. So sometimes contractors may misuse those articles because the loss of profit. I expect the new contract could deal with this particular issue. So why does the standard avoid the lost profit? The other panelists talked about that, and our presentation is there. I'll try not to duplicate or repeat what has been covered by my colleagues, but my presentation can be shared with you through LinkedIn. Conclusion, IBCC is offering a transformational change, because force majeure is based on ethical principles. And it only doesn't determine the legal part and the compliance and the Sharia, Islamic Sharia, and to focus on equity and also fairness, to share risks with both parties and maintain the contractual spirit. And the distinctive feature, the one for the no lost profit. And it's an alternative, a viable alternative, and provides an ethical framework that is aligned with the Islamic Sharia. I've tried to be as quick as possible. Sorry, I didn't cover all slides. I skipped some slides because we are running out of time, And the presentation is available for you to review and to benefit from. Thank you very much. Good. Thank you. Thank you. Those are the references that you can also check. Those references to be published. And this is the appendix for the presentation. Thank you, Doctor. Thank you very much. Do you have any questions? Thank you, Doctor. You know, during the pandemic, you know, we had an issue with regard to force majeures, and some contracts had, because the suppliers would take forever to supply, so that impacted the contracts. During the pandemic, it was critical. Even courts tried to strike balance between the interest of both parties with regard to compensation. And because some contractors during the pandemic, they were really impacted negatively by the delay of the supply or the delay of receiving equipment. So people during the pandemic were also working, but the supply, we had some issue with the supply because the supply would come from China and other countries. And that subsequently delayed the execution of many projects. Thank you, Doctor. Thanks to my colleagues for their comprehensive elaboration. We still have 5 minutes to go. We will have 5 minutes now to cover some of your questions. Then we still have other sessions afterward. Do we have any question from our audience? Please, go ahead. Please. Can you kindly give him the mic? Hello, everyone. This is Engineer Ma'tazem Al-Malik, an arbiter and the engineering expert. Dr. Saboni, what I understood from your the loss of profit is final, so the contract will not allow loss of profit. However, other speakers, the other panelists said that the loss of profit can be appreciated, can be estimated, but there is no final so the loss of profit, is there a Sharia or Islamic text that forbids the loss of profit? As far as I know, this is applicable whether in the court or in arbitration, of course, giving certain circumstances. So the contractor, when he prices its loss of profit, it is based on some contractual agreement. However, there are circumstances where the contractor can be compensated for the loss of profit. So is the loss of profit is final? Is not allowed in the Islamic and the current? Yes. Thank you for your questions. First of all, I would like to focus on in the event there is force majeure to determine whether there is termination of the contract. We have a contingency for amendments and for contingencies to terminate the contract. So if we have a force majeure that terminated the contract, I think, my understanding, for the 36th, this 36th article, IFS, in that case, there will be no compensation. There is no lost profit because there's a force majeure by God, or therefore, to be precise, the IBCC 2025, I believe I've received it lately, so I will refer the question to Kamal. My understanding, the loss of profit contradicts. My understanding, the loss profit contradicts with Sharia, because. So maybe, Dr. Kamal, what do you think? In the name of Allah. The loss of profit is very critical and has been discussed thoroughly. The contract, the contract will be applied in countries that apply civil defense and not apply Sharia. So, and even both ways. So the loss of profit is referred modern dispute educational board. Those board are 3 people assigned by the contract and assigned by employer and assigned by an independent. Those 3 people will look at the loss of profit and whether it contradicts or not contradicts with the Islamic Sharia. And depends on the merits, and depends on the circumstance, and depends on the law and legislative frameworks. This contract, this is not final. There's no final. There is no final. There is nothing final about loss of profit. It depends. So there is no final, but it's open to the modern dispute board. They will decide based on the jurisdiction and based on the law. Thank you, Doctor. A short comment. In my opinion, in my view, when I received the contract, I thought that what has been it's based on IFE 636. My understanding, this IF6, this gross profit is not prohibited, is not allowed, is not allowed. So I believe the model, this new model, is subject to the discussion of the board. I think there are in the arbitration granted some the loss of some arbitration, so granted some loss of profits. But if there is a force majeure, if the operation stopped in the project, if the employer terminated the contract, if the employer determined the contract and stopped the operation, in that case, the contractor has his staff. The contractor has staff, has equipment. The contractor has cranes, equipment, scaffolding. The contract obviously will be subject to loss. So if the employer stopped the operation with no particular reason, unjustly, if the employer unjustly stopped the operation, therefore the contractor will be at loss. And we've had cases where the contractor asked for a loss of profit, but it can be estimated, can be 5% or 10%. But I know that there is a case, 9% of loss of profit, because the arbitration has Islamic background, therefore it's allowed by Sharia, by Salah. IUFA, I don't remember, and one page number 100, page 8, and that in the case of force majeure, IUFA is not allowed. For IBCC combined both. IBCC is combined both as very flexible. Do we have any other question? Any other questions? Sorry, there was a lady. Sorry, yeah, there is a lady who wanted. The mess wanted to ask the one behind you. Sorry, my apologies. Hello, everyone. This is Ghada Jabr. Contract engineer. My question is the responsibility of the consultant in approving the payments. How can the consultant be held accountable for delaying the payments? If the consultant doesn't approve the payment, he can be held accountable, or the contract is between 3 parties. The second question is about the commands for variations. You highlighted that there should be an agreement about the cost of variation. If the contractor started the execution without any pre-agreement, so the contractor can receive the same amount or the same fees. Does that mean if the employer asks the contractor to do the variation, that means they have an agreement on the rate on that for that new amendment or new variation? Since the contractor started the work without any objection from the consultant, without any objection for the employer, if the contractor starts the variation and started the variation or started the work, therefore, this is embedded agreement that the contractor agrees on the execution, the rate. However, this verbal consent, there is no value, the value of the unit. Not determining the value of the unit doesn't negate the right of the constructor to ask for the rate or to ask for the specific fee, value. So you are an engineer, you know the rate, you know the value for the unit. So if they started the work, if the contractor started the work without identifying the rate of the unit or the value of the unit, they can identify it later because everybody knows there is an agreement, there is a consistent agreement about the price or the value of the unit. Even the verbal command in the BQ, our reference is BOQ. Sometimes we have an article in the contract to make a BOQ as a reference in terms of pricing. Do we have a specific percentage? We have it on the contract. We have an article on the contract that you cannot change the price in the even if they change in the market. If the price in the market, the price in the contract cannot be changed, even if the price in the market changes. So the contractor, what price? There is an article in the contract that determines the price. And if the price changes in the market, they stick to the price in the contract. But what happens if the price is not listed in the contract? So it's an agreement. It's consent between both parties. For your first questions about the liability of the consultant when he delays the approval of the payments, will he be held accountable? Certainly, the consultant is not a party in the contract. The consultant is not a party of the contract. He is only representing. He represents only the employer. The contract, the Islamic contract, gives the right for the contractor to asks the consultant when the consultant delays approving the payment. Therefore, the contractor, based on the Islamic law, based on the Islamic contract, the contractor can contact the consultant and asks him to expedite the approval process of the payments. So the contract gives the right for the contractor to contact the consultant as in his capacity as the representative of the employer and asks him to expedite the approval of the payment. And obviously the consultant is assigned by the employer. There is a very important point that Dr. Bashar highlighted with regard to the second question about there is a percentage in the contract which is 20%. The percentage cannot exceed 20% for the additional work. If the additional work exceeds 20%, then there should be a new agreement. If there is no new agreement, the employer will ask verbally. This verbal request, sometimes the contractor will send a price. If the consultant objects on the price, therefore they have to negotiate the price. If the consultant does not object and accepts the work, that means the consultant agrees on the new rate. or the real price. I think, for me, I think the contractor, I think the consultant can be held accountable for delaying payments, because the consultant represents the employer, and to issue payment, if there is any delay in payments, therefore the consultant should be held accountable. The Benedini contract holds the consultant accountable. There are new contracts, there are new contracts. Every contract has its own contract. We see, if this claim is being escalated to the arbitration, the consultant can be considered not a party of the contract. Therefore, he cannot be held accountable to pay any fines. But the notice is there. The notices are there. The notices from the contractor to the notice can be presented as evidence that the contractor notified the consultant about the delay of payment. It's very complex and tricky, because let's not go there. I think we will take the last question. This is the last question. Fatima, you asked earlier. Let's ask allow somebody else to ask a question. Here. The last question here.
We will give the question to peace be upon you, Dr. Mahmoud Abdel Hal. I am the chairman of the Arab Network for Innovation, and I am specialized in the finance, Islamic finance. Thank you for this model. I don't have specific questions really, but I have an intervention in this first model launch of this contract. It needs controls, special controls from Professor Soyuni, as he said, the 36 standard and the standard of manufacturing also, and the parallel manufacturing. And there are a lot of items that need control. All the points that have been discussed in this session, after the nice presentation from the three panelists, great panelists, I think this contract needs cooperation between the Conciliation and Resolution Center and IOFI to issue a standard, specified standard to control this contract. Today you need to present this contract to the community and the society. There should be legislative standards, and this is a consultancy because the center does not have the power to mandate this contract on the certain sectors. But if there is a center, legislative standard, and Dr. Kamal might benefit us from this topic, if cooperation between IOFI and the center, I think this contract will be developed greatly and remarkably, because there will be a draft for the standard and a revision, and there is a specialized standard will be issued in this contract, because I think this is very important in the Islamic finance and the industry of the Islamic-based construction contracts. I hope that this will be taken into consideration. Thank you so much. The story is about IOFI focuses 90% on the transactions, Islamic transactions, and the Islamic finance. This is the main interest of IOFI in order to avoid usury, or it is one of the contractual means to avoid such things. This contract really is a construction contract. This is existed and drafted by the colleagues in order to have an alternative for FIDIC contracts and EGCT contracts. So it is an alternative contract for the contractors, the owners, to use it instead of the foreign contracts. Number two, this is in the processing phase right now, and the good thing is it was issued from the UAE, and Dubai might be one of the cities that have a lot of cranes, building cranes in the world, and the size of construction is not existed in any place of the world, and it has also multi-cultures and a different legal environment. All these experiences are put in this model. It is not a final model. It is a changeable and an updated model. But I think maybe 30 years ago when I was working on FIDIC, and we said we will do something for the community that align with our community, and the people made an exerted efforts. And thank you for this point also. Ms. Fatima, I will go back to you. Because we are friends, I would like you to ask a question. Maybe you will agree that the force majeure causes disputes in all contracts, not only the construction contracts. Does this contract stipulate clearly to tackle the force majeure, either natural or human-made, and the force majeure effect cannot be implemented in the contract? The force majeure, it is the natural force majeure. It is not human. It is beyond the human willing and the parties. So it is an act of God. So it is natural, maybe. So this is the definition of the force majeure. But the other topics, like for example, the small difficulty or anything that Dr. Bashar talked about, like for example, if there is something that does not necessitate to terminate the contract. So this is the definition of the force majeure. I would like to seize the opportunity, and we were talking about AI. I propose, Dr. Kamal and the people who are working in this field, we should be a step ahead of this thing. In the American Association of Arbitration, some weeks ago, they approved and adopted the AI arbitrator. If we have an AI arbitrator, we will do nothing. So someone can apply for the arbitration, AI arbitration, and the AI asks him questions as if he takes more questions and help him to prepare the application to save time and then go to the arbitrator. So I suggest that this contract should be followed to minimize the time and save time. As Dr. Kamal said, it will be updated continuously and not only updated like other codes every 1 or 2 years. I propose that this should be transformed to a human being, and the AI is an assistant, provided that it will not take the place or replace the arbitrator, but it assists and facilitates everything. Following what you have said, Ms. Fatima, I think the force majeure, it should be left for the law, the civil law, which will tackle this issue. I really saw some provisions in the contract, like for example, the workers' strike, like a force majeure. And it is considered as a force majeure, which is wrong. There should not be manipulation in this thing. Force majeure is something beyond the willing of a human being and unexpected. It is natural or by the act of God. And the implementation of the order is impossible. If it is exhausting, they will lodge to the court and settle the payment. In this, we would like to finish our presentation and thank from our heart to Dr. Ayman Bashar and Professor Abdul Rahim and all the panelists for this valuable information they have presented. And we hope that we all are able to enrich your information in this topic. Thank you so much. We would like to thank all the panelists and the speakers for their efforts and their contribution that added a lot to the conference, a fruitful thing. And we also would like to thank the organizers and call them for the recognition. We start with the Mr. Muhammad Rashid Aswaidi, the co-founder and the Director General for Aswaidi and Partners. Dr. Engineer Ayman Kamil Najjar, the Secretary General of the Arab Union for Real Estate and Development, Construction Development. Dr. Engineer Bashar Tassis Samha, the Deputy Chairman of the Arab Union for the Real Estate and Construction Union. Professor Abdulrahim Sabuni, the academic consultant for the Center of the UAE Researchers. We also would like to call Dr. Ayman Kamil Najjar for recognition. Ladies and gentlemen, esteemed guests, we are happy to have the lunch for the conference as an opportunity for networking in a friendly atmosphere. So you can join the lunch, please, outside the hall in an atmosphere of friendly and networking. Thank you.
الحضور الكريم، ندعوكم للحضور للبدء في الجلسة الثالثة بإذن الله تعالى.
Welcome you back again to appeal our sessions in the third session titled to the mechanisms of determining final payment values in the contracting a project under the model Islamic-based construction contract. This session is extended to what has been discussed in the constructive oversights and discussions to tackle the topic about the delivery and guarantee, which is the crown for the contractual relationship between the parties. We are happy to announce that Mr. Ammar Ahmed will moderate this session, the executive for the Sharia Dar, or Dar Sharia, and participated in this session Engineer Wissal Na'ma under the controls of the final payments for the construction. Mr. Lejinsky Aydan in his paper about the procedures to deliver the project and the issue of completion certificate, or Leonora also in the controls of guarantee and the flawless freement of the model Islamic contract. This session will open prospect to understand the Islamic contract, to control the contractual relation after implementation. Welcome you again, hoping that this session will be fruitful as an extension to the works of this conference. In the name of Allah, the compassionate, the merciful, peace and blessings be upon his messenger, kith and kin, and his followers. Yes.
That we have. And in our panel today, we have three very, you can say, expert panelists and speakers. And the way we will handle this session is I would like to invite each of them to share their thoughts on the topic, and subsequently
We will take questions, open the floor, and have any conversation from the presentations that the participants make. So the first topic that we will have today is for Engineer Visal Nima, and I request her to speak on the topic of mechanism for determining final payment values in a contracting project under the model IBC. So I would respectfully invite Engineer Visal to share her thoughts. You have the mic there.
Okay, working? Okay. السلام عليكم ورحمة الله وبركاته. بسم الله الرحمن الرحيم والصلاة والسلام على سيد المرسلين خاتم الأنبياء سيدنا محمد صلى الله عليه وسلم. Thank you Ahmed for the kind introduction. بالبداية أود أن الدكتور رامي ودكتور كمال على هذا الإنجاز.
Congratulate Dr. Kamal and Dr. Kamal and this phase for the center to inaugurate the Islamic contract 2025. In fact, these efforts were crowned by the actors of the Injaz Center and the achievement of this important phase of this contract. We have seen in the previous papers that how all the research say that the contract was drafted based on the principles of the Islamic Sharia, taking into consideration the principle of equity and clarity and avoiding the al-gharar or negligence in the contracts. The purpose is to achieve the purposes of the Islamic Sharia and to apply the principle of revealed in a chapter in verse 29, all believers, do not eat your money between you unless you are consent on that. And following these principles that were presented by the researchers a moment ago, we will touch on how the contract has been drafted regarding the final payments for the contractor, and taking into consideration all these principles that were mentioned in conformity with the principal purposes and principles. The principles were drafted to present the payments by the end of the project and the completion of the project in 3 phases of payments. When the project is completed, the first the payment at completion, and we have also a payment stipulated in the contract, which is the draft final certificate and the final statement of accounts also, FSAA. Of course, this method or mechanism for payment deals with the principle of transparency and the absence of the purpose, and to reduce the sources of conflict and dispute in the construction contracts. The contract stipulates some provisions regarding the final payment, which is called the payment at completion, PAC, clause 25.5. It stipulates a mechanism to present the payments that the contractor, when the certificate is issued, he will present the final payment within 45 days to the engineer. Of course, he should present it in a form stipulated in the contract, and one of the requirements and the documents also should be annexed to any payment. Also, the contract stipulates the engineer within 45 days from receiving the payments, he will conclude a meeting with the parties, which are the contractor and the owner also, and try to reach to the amount that should be spent to the contractor. In case of any claims adopted by the consultant, or in case of the dispute or anything. In case they cannot reach an agreement regarding the final payment, the engineer will sign it and issue it and transform any dispute to the mechanism of resolution of the disputes between the parties of the contract. Also, the contract stipulates that any party, either the owner or the contractor, they have the right to object the amount that is approved by the engineer, and within a period which is 30 days. Unlike the disputes present between the contractor and the owner about the final amount, the payment will be spent by the owner and transfer any disputes according to the mechanism in the contract. Also, in case of the engineer approved the payment, the contract within 5 days should present the payment, which we call the VAT. And the owner also should pay within 5 days as of the issue of this payment by the engineer. The engineer should review it within 5 days, and the owner should pay the entitled payment within 15 days, unless the amount of the payment is zero or negative.
There are articles in the contract that both parties have the right to object on the payment that has been approved by the engineer, and they can object that, and they can resort to any legal means to resolve that disagreement. The second payment that should be issued after the performance certificate, which is number 25.5, draft 5 panel certificate. The contractor should present it in 60 days after the issuance of the performance invoice. And the format has been also highlighted by the contract, and it recommends that the payment should be cleared within a specific period of time. And there should be an electronic copy and hard copy as a receipt for the payment. This payment, the draft final payment, contains some requirements stipulated in the contract, like in the event of any additional amount, or the total cost of all the work that has been achieved or has been executed by the contractor should be highlighted in the payment that will be issued to the contractor. The contract stipulates or highlights another mechanism, which is the final statement of the account. This is the feature that we have in the Islamic contract, which is the contractor presents the final statement to the owner and to the engineer and determines and highlights the due amount and the remaining payments, whether the whole previous payments have, the due amounts or the payments that have been cleared. So the contract stipulates that the contractor has every right to send a notification to the owner that highlights the payments that have been cleared and the payments that are still due. And if there is any issue or dispute over the total amount of the payment, then that dispute can be resolved in 45 days. So, and the owner can either make the payment or can object to that statement presented to him by the contractor. And then he has also to present the discharge letter. Then the owner may agree on making the payments that have been agreed on, and in that case, and if not, and if there is no agreement between the owner and the contractor, then they can resort to the articles in the contract that shows what happens in case of dispute. On the basis of this contract, contract highlights a very clear mechanism where the contractor presents the whole payment, either the final payments and the due payments, and the point here to reduce the potential disputes about the due payments due to the contractor and the time that this payment should be cleared. And if there is any dispute over any payment, that doesn't mean that the owner or the employer has the right to hold those payments that have been agreed on. Thank you. Thank you very much.
She's at the IFC Arbitration Center, DIAC, listed arbitrator, and also at Ajman Center for Reconciliation. She brings in more than 27 years of experience in civil engineering and specializes in claims management and dispute resolution. She heads a section in a leading engineering consulting firm, managing complex cases, determining the root causes, and assessing the responsibilities of the parties, and also delivering the assessment of infrastructure and projects across various sectors, government and private. So she, with her experience, has contributed to the contract, and this was very evident from her presentation now, where she articulated the specific clause which deals with how the payment mechanism has been captured in the model contract. We will now move on and we'll take questions, inshallah, once we conclude all the three sessions. I now move on to Mr. Victor, who is a chartered arbitrator and certified mediator. He's a fellow of, in addition to being a chartered arbitrator, he's a fellow of Chartered Institute of Arbitrators. He holds a JD and a B.Ed from Canada. He has served as arbitrator in more than 120 cases. And a significant part of these cases were high-value construction cases and conducts both institutional and ad hoc arbitrations. He is a certified mediator through Center for Effective Dispute Resolution in the UK, works frequently in respect of mediation with the Royal Institute of Chartered Surveyors and Chartered Institute of Arbitrators. He has conducted and conducts mediation, including construction-related mediations. He confines his practice to that of a neutral arbitrator or a mediator in construction and energy-related disputes. Victor is an elected member of the steering committee of ICC UAE Commission on Arbitration and Alternative Dispute Resolution for the term 23-25. He's a past MENA chapter director of Association of International Energy Negotiators. Victor sits on panels of many arbitration institutions around the world. He has experience in PPP, including being sole arbitrator in two large complex African government cases. Two complex cases, African government in partnership with two private two-party joint ventures, and in construction projects with various forms of privately financed infrastructure. Victor is a Canadian citizen, but has been a resident of and has been working in Middle East for more than 18 years. So he knows the region very well. Victor has served as a regional pathway leader for Chartered Institute of Arbitrators and tutors award writing amongst other courses. He instructs and assesses in respect of arbitration and mediation through the Royal Institute. He lectures frequently on various topics, that we've all mentioned. He has won awards, the key of which was DIAC, Dubai International Arbitration Center Award in 2018. So it's a pleasure and honor for us to have Victor, who brings in the wealth of experience and expertise to the panel today. I would invite him to speak on the topic that has been provided here, mechanism and procedures for project delivery and issuance of completion certificates under the model contract. The floor is yours, Victor.
Thank you. Thank you very much. It's a pleasure and an honor to be here. I thank Dr. Kamal and all the other people on the committee for inviting me today. It's, as I say, a very great honor because this is a very innovative idea with this new contract, this modern contract. The innovation is really for efficiency. What I see when I look at the contract, it's got efficiency all throughout all of the sections and articles of it because it has short timelines. It makes sure everyone is doing their duty diligently. And as a result, anyone who works under this contract will certainly have to keep good records, ensure that they are meeting all of their timelines, and all of that sort of thing. As Engineer Wissal pointed out, she was talking about payments under the contract. Of course, that's the lifeblood of any construction project is the payments. And so what I'd like to do is just begin a little bit with the UAE Civil Code, because there are some provisions that we have to keep in mind. For example, Article 874, in a Mukawala contract, there must be a description of the subject matter, the particulars are given, and the manner of performance must be set out. And so that what the modern contract does is cleave to the UAE law to make sure everything is specifically set out. Article 877 has the contractor completing the work in accordance with the contract. If it's impossible, if performance is impossible, then of course the employer can terminate the contract. But if it's at all possible to perform under the contract, then the contractor has to do it or has to repair the works within the time set out. Moving more to our topic, which is taking over and completion, Article 884 says the employer shall be bound to take delivery of the work done when the contractor has completed it and placed it at his disposal. And if, without lawful reason, he refuses, despite being given official notice to take delivery, and the property is destroyed or damaged in the hands of the contractor without any wrongful act or default on his part, the contractor shall not be liable. So it's, I think, the modern contract that we're talking about today keeps that balance. I think what the line on the screen behind me says, it's a balanced contract, and what the framers of the contract were trying to do is create that balance, I think. And you can see that in the UAE law as well. Article 885 says the employer shall be obliged to pay the consideration upon delivery of the property contracted for, unless there's agreement or a custom to the contrary. So clearly, as Engineer Wissal says, it has to be paid, and all the payment provisions have to be met with the timelines clearly adhered to. Article 886 says if a contract is made under an itemized list on the basis of unit prices, and it appears during the course of the work it is necessary for the execution of the plan agreed substantially to exceed the quantities, the contractor must immediately notify the employer thereof, setting out the increased price expected, etc. So obviously, if its prices are by an itemized list, there has to be that communication quickly. And again, the modern contract sets that out and makes sure that efficiently all of the notifications are given diligently and quickly. And it has, I would say, shorter notice periods than some contracts, shorter certainly than the common law. If you contrast it with the common law, it's much more efficient, I would say, the modern contract. So those are the basic provisions of the UAE Code about taking over. Obviously, the taking over provisions are largely in Article 21 of this contract. Article 21, 1A, subject to minor work to be completed, successful completion of all required tests, and the employer has taken possession or has been formally handed over the project. And again, it's the engineer that determines if the contractor's request to hand over the project should be complied with or not. The engineer must specify the remaining work, defects to be corrected, and or documents that must be submitted. The contractor must complete the necessary work, correct the defects, or provide the required documentation before reapplying. Inaction by the engineer will result in deemed taking over. So again, each party has to do their work diligently, meet the time frames required, and do what is specified in the engineer's notice. Some definitions, Article 1.19, the DLP period is 1 year. Article 1.64, use or occupation by the employer may result in deemed taking over. So obviously, if the employer commences to use the project or the building or the subject matter of the construction contract, then it's deemed taking over. Article 1.68 means that the tests, if any, specified in the specification and carried out in accordance with the special provisions after the works or a section thereof have been taken over under Clause 21. So there are requirements to meet the tests to make sure that all of the aspects of the construction are suitable for the purpose for which they have been constructed. So everything has to work, subject to minor things. Article 20 talks about tests. At least 15 days notice must be given by the contractor prior to completion tests unless a particular test requires more notice. The contractor initiates finalization process. The engineer agrees or gives notice of what is lacking. No action from the engineer in 15 days result in a deemed pass of the tests. So again, a 15-day notice, very efficient. Everyone has to do their duty within that short period of time. Article 20.2 talks about delayed tests. There has to be an interaction, good communication between the contractor and the engineer to ensure that the tests are completed if the tests have been delayed for some reason. Article 21.3 talks about interference with the completion tests. This is a notice of prevention. So if the employer interferes with the completion of the tests or with the conduct of the tests, then it can be seen as a deemed taking over by the employer if they interfere with the tests that have to be completed in order to do the taking over. There's also a partial taking over certificate, a PTOC. It's a certificate that's issued by the engineer for taking over part of the project works. The TOC, the taking over certificate, is issued by the engineer for the taking over of all parts of the project work. And then there's the final taking over certificate, which Engineer Wissal talked about in terms of payment. The FTOC, the final certificate issued by the engineer for handing over all project works and the end of the DLP. Time for completion means the period for completing the works or a section thereof as applicable under subclause 18.2, time for completion as stated in the contract. It may be extended under subclause 18.4 calculated from the completion date. So the bottom line really is we are looking at contractual clarity here. I think this contract is clearly written. All of the duties of all of the parties are clearly set out in a fairly short and efficient time frame. I think under this contract, it should be easier to complete projects in a quicker time than currently is done. The second is notice and notification. Contractors should provide written notice to the employer and the engineer regarding potential claims and additional costs arising from additional handover procedures. Documentation, maintain detailed records of all communication, agreements, and transactions related to the contract and the handover process. UAE court decisions, one has to keep an eye on court decisions that construe or interpret the sections of the Civil Code and various scenarios that occur in construction situations under where there's disputes. Lastly, people should always seek professional advice, whether it's engineering advice, whether it's claims advice, whether it's legal advice. Certainly there are excellent lawyers in this room that people can contact and talk to, excellent claims people, excellent engineers here. So that's what I'd like to say about taking over.
Thank you very much, Victor. So we'll move on to the next topic, which is warranty mechanisms and defect liability periods under the model IBC. For this topic, I have the honor of inviting Leonara Reisenberg. She is international chartered arbitrator, adjudicator, and accredited mediator, certified alternate dispute resolution practitioner, leading international trainer in ADR. Leonara is an accredited mediator at INTADR DMCC Dubai and an international tenant at Gray's Inn Square in London. She's a fellow of Chartered Institute of Arbitrators, a fellow of Asian Institute of Alternative Dispute Resolution, and stands as a leading figure in international arbitration, mediation, and alternate dispute resolution across Middle East, Asia, and the UK. She is highly specialized in high-value complex disputes across key sectors, notably in power, energy, investment, infrastructure, construction, joint ventures, partnering and shareholder disputes, banking and finance. Her affiliations with prestigious arbitral institutions, among them the ICC, the LCIA, the SIAC, the DIAC, ADCCAC, SCCA, APIAC, MIAC, AIADR, solidify her standing as a leading figure in international arbitration. Her global influence is reflected in her service with leading dispute resolution institutions across jurisdiction. She sits on advisory board of Indonesia International Arbitration Center, the governing council of Hyderabad Arbitration Center in India, the city where I come from, and the global advisory panel of the Musaliha International Center for Arbitration and Dispute Resolution in Pakistan. Her leadership is further demonstrated through her past roles as a branch chair of Chartered Institutes of Arbitrator in UAE, an elected member of Board of Management of Chartered Institute of Arbitrators, London, and as a member of the IFC Courts Arbitration Working Group. She's also a member of LCIA Arab Users Council, Swiss Arbitration Association, and a sought-after faculty member. She regularly teaches internationally for various institutions across MENA and the UK, and she has played a key role in shaping the next generation of dispute resolution professionals. So I would like to invite Leonara to speak on the topic.
Thank you very much indeed for the introduction. It's a real privilege, a pleasure to be here. My congratulations to the organizers, the IICRA, our patrons. We are grateful to have them on board. Dr. Kamal Malas, thank you for the invitation to speak today. We are all indebted to all of you, But today we are celebrating something absolutely sensational. I know that a number of people in this room have been invested throughout over a year to bring this model contract into place. And we now have heard how efficient, how fair some of the provisions are, and I have the pleasure to address warranty mechanisms and defects liability periods, and to also celebrate how balanced those provisions are too. Now let's start off by looking at it conceptually. Why are warranties and defect liability frameworks important? Well, because they sit at the intersection of risk allocation, performance assurance, and project closure. And what we tend to see a lot of in the Middle East are disputes that tend to crystallize towards the end of the project, particularly when it comes close to those payments having to be issued. And this contract is truly creative, truly innovative, and it aims to draw a line and to bring finality to the parties, both employers and contractors. Looking at the warranties in the IBCC 2025 first edition, I'm sure there will be many more, but the first one is truly sensational and one to be celebrated. And I just want to highlight that this is a construction work designed by the employer, so we do need to remember the essence of the model contract that we are looking at. But when we look at the warranty provisions, we've got warranty provisions that are personal in nature, and I will broach upon that shortly, but also technical in nature. So two sets of warranties. If I look at the personal warranties, well, clause 2.1 is a good starting point. And what that does is it imposes express warranties of independence on the chair of the MDAB, so that's the members of the Dispute Adjudication Board. And of course, we've got very innovative, modern ways of resolving disputes using DAB. So the chair has to make an express warranty. And there is a continuous warranty throughout the term of that appointment. And that is something that is consistent with international best practice. All of you who are involved, certainly in arbitration, will be aware of these continuous duties when it comes to disclosure of potential conflicts of interest. It also demonstrates the IBCC's treatment of warranties and ongoing representations that speak to professional integrity of the individuals that are then appointed to determine those disputes. On conflicts of interest, of course, no one in this room needs to be reminded that there is an obligation to disclose any fact that may call into question the independence or the impartiality of the individual making the disclosure. And it is a self-renewing warranty because of the duty to make those disclosures throughout the course of the process. It is a self-renewing warranty, and it's important to point that out. Of course, that in itself lends to trust and confidence, not only in your dispute resolver, but also in the process and the contract that underlines it. In terms of professional qualifications, well, of course, very important to have the right man or woman for the job. Well, our model contract states that the parties are to rely on the chair's representations of their experience and their expertise. So you can see that that converts to a contractual warranty, where you are very much going to be taken to your word in terms of your experience and your expertise, and it must be accurate, it must be trustworthy. Under the IBCC 25, warranties are not just about materials and workmanships, and as I've just set out, albeit at a high level, we all can see that extends to behavior, to expertise, but also to these fundamental disclosures that underline the entire process and ensure its integrity. And that's very much a modern approach, and one that is to be celebrated. I then move to defects liability and the life cycle of completion of a construction project. Well, we've heard about payment terms, and of course, they are very important indeed. We've also heard about potential difficulties that may lend themselves to getting payments released. But we've got some really good news here. If you look at the way that this model contract has been put together, we have partial taking over as well as taking over certification. So that enables contractors, subcontractors who have partially completed the work to ensure that those bits of work get taken over and in turn that they get paid for those portions of work that have been completed to the employer's satisfaction. And I will say a few more words about this by reference to the contract itself, but just want to set the scene. So once we do have a TOC, so that's your taking over certificate, or your PTOC, your partial taking over certificate, that's what triggers your defects notification period, your DNP under the contract, which is, as Victor Luginski has rightly stated, typically 1 year. There are a few provisions that may apply that could potentially extend that period that I shall touch upon briefly this afternoon. And I would certainly put an argument out there that these kind of mechanisms are superior to the traditional textbook FIDIC red books that have been very popular in this part of the world, and that only use a single defects notification period after overall completion has been achieved. It also allows for flexibility, certainly when you've got complex construction projects. But here's the part that I enjoy the most. Now let's assume we have a scenario where an employer has taken over part of the work before final handover. Well, in these kind of circumstances, under most contracts that I use, including the FIDIC contracts, it's a bit of a grey area, and it does lend itself to no end of argument. Well, we've got clause 21.2, unilateral taking over of parts of the works, that comes to our aid. And what that clause effectively says is that the engineer may issue a TOC unilaterally for parts of the works. And that can happen where the employer uses a part of the project before formal handover has taken place. And once used, then that part is deemed taken over. There's no room for argument. The clock starts for your defects notification period. And that's set in stone in the contract. Importantly, what these clauses do is they bring about a great deal of fairness, but they also do ensure that contractors get paid for work that has been unilaterally taken over ahead of time. Well, let's see what happens in case of defects after taking over, whether it's partial or all of the works in question. I'd like to draw your attention to clause 22.1, completion of outstanding work and remedying defects. And that provision sets out a dual obligation. First, to complete outstanding work that has been listed in a TOC, so usually they will be qualified if there are outstanding items that need to be addressed, any defects that need to be addressed. And the second obligation is then to go and remedy those defects that have been notified during the defects notification period, which is clearly defined. The mechanism is precise. The language of the contract is that precise that it lends itself to its natural conclusion, and that's something else to be celebrated. There's a great deal of procedural fairness in allowing for closure where certain acts take place. For example, the one I mentioned earlier, where an employer decides to take over part of the works. A good example there, it's not here on paper, but it does come to mind. Say you have two buildings, two towers, and one is complete and the other isn't, and one starts being operated. Well, it makes good sense to pay the contractor for the works performed that have been taken over, that are being operated. This contract allows for that. There's also a cost matrix for remedial works set out in clause 22.2 that's worth sharing with you. And that sets out a mechanism for payment of costs of remedying defects that lie outside of the contractor's responsibility. The age-old arguments that we will see in construction disputes, whether it's litigation, arbitration, or other processes, there are always arguments about variation orders not being issued. Well, here it makes it very clear that if those defects have been put right, they have been remedied, and they lie outside of the matrix of responsibility of the contractor, then those works are going to be treated as if there were a variation issued or instructed by the engineer. You can see a lot of thought has come into this, and certainly those that are going to be using this contract are going to find that it will lend itself to a natural result that it's fair, and I would say to both contracting parties. I did mention earlier that the one-year defects notification period may go longer. Well, that's an exception to the rule, but let me then take you to a provision that deals with the extension of the defects notification period that appears at clause 22.3. And it provides for an extension mechanism of up to 2 years beyond the original period. So that's 1 + 2, 3 in total. But only if the works cannot be used for their intended purpose due to a contractor attributable defect or damage. So again, we've got a lot of certitude that is brought into the mix. We're only looking at 1 year and drawing a line, finalizing the account and the accounting situation that normally arises at the end of the project. Or if there is a contractor attributed defect, then the employer may well extend by a further period up to 2 years in order for those defects to be addressed and to be put right. And that's a natural evolution. It's a natural evolution of the contracts that we are currently familiar with and using in practice, in industry and practice, and introduces this wonderful conditional extension, not an automatic one, it's conditional, and it's conditional on the contractor having done something that they shouldn't have done, there's fault attributable to the contractor, and for that reason alone, that period is extended. What this clause also does, and you can see that a lot of potential disputes are very quickly disappearing whilst we are having this discussion. And I'm sure you've got all kinds of scenarios in your mind. I've certainly got quite a number in mind that I'm very happy to share during the break. But what it also does is it clarifies that suspension caused by the employer will not extend that liability period. We're not going to have the usual tactics that sometimes are deployed to delay or defer making payments of final accounts. This contract won't allow for it. Now you might come to me and say, okay, well, what happens if poor contractor doesn't get access to put everything right? Well, let me take you to clause 22.7, right of access after taking over. So even after taking over, that's the employer's taking over, the contractor retains a right of access. And that's for 28 days following issuance of the performance certificate to complete any remaining obligations, provided that such access does not conflict with the employer's reasonable security measures. You can see, again, very balanced. You can come in and remedy, address anything that's been left over, that hangs in the balance so we can tidy this up. Can't do anything that will conflict with the employer's security measures. Well, simply the employer's already taken it over. And again, great provision, because it then goes on to say that if access is unreasonably denied by the employer, the contractor can recover additional costs at reasonable profit. So if we've got bad behavior, and we've all been exposed to bad behavior in the industry, well, you're going to be responsible for additional costs at reasonable profit. So that is a great balancing act and a great safeguard to potential abuse. So let's go back to the money. So I started by saying, we talked as a panel about money. I'm sure we're going to keep talking about money because essentially that's what it's all about. People providing services, providing works and getting paid for it. Well, how do we get funds released after this process has come to an end? And very briefly, I do want to take you to two further clauses, so do bear with me. The first one is clause 25.7, release of retention money, and that ties a release directly to the expiry of that defects notification period we've been talking about. We've got 50% that gets released on taking over or occupation, so that removes room for argument as to whether taking over and occupation are synonymous. And it also states that the balance 50% will be released upon the latest date of expiry of all defects notification periods. But what I really want us to appreciate here is that if you've got sectional taking over or sectional occupation, clause 2210, which is the second clause I wanted to refer to, but allow me to do it now. So let me stay with 25.7. I'll come to 22.10 in just a moment. But the same clause, 25.7, what it allows for is those payments in release of retention to be pro rata for the first half. So if you've got sectional taking over occupation, then 50% pro rata will be released until the full taking over certificate is released or the full construction works are occupied. Well, that's revolutionary. The balance gets paid on the expiry of all defects notification periods. For that, you need to wait a little bit longer. But you can see that a lot of payments are being made sooner than we are seeing at the moment.
Okay.
Great contractual architecture. And now I'm going to turn to 2210, the unfulfilled obligations. Well, there's always that conundrum of what happens if there are still some unfulfilled obligations. Arguments that are always used in this marketplace. Something has been left undone. We are not releasing the final payment. We are not releasing the balance retention. But this clause is fabulous because it confirms that even after the performance certificate has been issued, any unfulfilled obligations survive. Despite the fact that you release that balance 50% payment in retention, any unfulfilled obligations survive. Classic continuing obligation clause has been built in.
Can I interrupt, and because we are running short of time, so.
Oh, that's quite all right. Feel free. I came to the end anyway.
Okay. You want to take another minute or so, just to conclude?
Well, if you've got a pertinent question, very happy to take it.
Okay. Now, I think we are running short of time, and we have another session to to take forward to, and we'll also would like to invite our guests here to have any questions specifically. Although we have, I think all the three esteemed speakers, they have highlighted on the key areas of the contract. And before I invite the floor or open for questions, you can prepare yourself. So I think the first part on the payment and the clarity that the provision provides for the payment has been emphasized by Engineer Wisal. I think it is important for us to know, because from a Sharia perspective also she highlighted that the payment related provisions between the parties must be clarified. The closest we have or the analogy we drive is the istisna contract that we have, and the requirements on the istisna. So I would ask a question to Engineer Wisal. In your opinion, how do you think is this model contract related to the istisna, or do you think all the Sharia provisions that are required under istisna are captured under this IBCC 2025?
بالحقيقة يعني اللي عند صياغة العقد هم أخذوا في نظر الاعتبار كل الجوانب اللي تخص الشريعة الإسلامية. بصورة عامة عقد المقاولات مثل ما تفضلت هو عقد استصناع من الناحية الشرعية. بالنسبة إلى الدفعات هي تكون على قيمة الأعمال اللي ينجزها المقاول ويكون مستحقة للمقاول استناداً على أنه المهندس قام بالفحص الأعمال وأكد أنه المقاول قام بتنفيذ الأعمال أو حتى ورد بعض المواد إلى الموقع. فبالنتيجة يكون المقاول مستحق لهذه المبالغ بناء على العمل اللي تم عليه. تم تقسيم الدفعات بالعقد لتتناسب مع كل مرحلة من مراحل المشروع. فخلال المشروع في المقاول إلى الدفعات المرحلية اللي تعتمد على نسبة الإنجاز اللي يقوم بها المقاول خلال فترة المشروع. تبعتها بالدفعات اللي هي الدفعات سواء كانت الختامية بمرحلتين، مرحلة اللي هي التسليم الابتدائي وفي عندنا مرحلة التسليم النهائي عفوا. وأيضا استحدث العقد ميكانيزم لأنه استلام للمقاول مستحقاته المتبقية بغض النظر عن كون أنه لسه في أي نزاع قائم سواء على مبالغ أو delay damages أو أي أمور أخرى هي بين الطرفين. فالحقيقة الصيغ اللي إجت بالعقد هي تحاول أنه تشيل العبء عن الكاهل المقاول بتأخير الدفعات، لأنه يعني أعطي الأجير أجره قبل أن يجف عرقه. فهذا مبدأ الشريعة الإسلامية أنه المفروض أنه يأخذ أجر الأعمال بدون تأخير، يعني مبدأ العدالة ومبدأ الأمانة ومبدأ الشفافية ومبدأ أيضا الغرض.
جزاك الله خير. Many thanks. I just wanted to ask Victor one question. So you've drawn comparison with the UAE Civil Code with the model contract. The aspiration of this is to be an international model. So in your view, if you can summarize how balanced it is for international adoption. UAE, you have clarified that it aligns well with the UAE. But what about the international aspirations of this model IBCC?
Thank you. Yes, that is a very good question because obviously we want this contract to be usable by contractors and employers regardless where they come from and under whichever governing law or substantive law that they want to provide to it. And it aligns very well with most governing laws that you can see, not only the UAE Civil Code, but other civil codes around the region. Certainly I have done arbitration cases in many different civil codes around the region and in France and in Europe and various other places. And it aligns very well because the point is, and I think Engineer Wissal said it very well in terms of it aligning with Sharia, it aligns as well with civil codes that I've experienced as well. And under the common law, one would have to take a look at it to see if it would work. I think it would because the basic provisions of the common law as expounded by the courts in the UK and other common law countries is that payments should be made, as Engineer Vassal said, if you do the work, you should get paid without delay. And I think these sorts of provisions align well as well with common law provisions because the courts want to ensure that people are paid for their work in a timely fashion.
Thanks a lot, Victor. My last question before I ask any of the participants to. So, Leonara, you've highlighted that this is a very balanced contract, and you are highlighting the merits of. Don't you think this contract has a potential to put arbitrators out of business?
construction projects. I'm sorry, the mic wasn't working. Thank you ever so much, Haytham. DABs tend to be more effective because you tend to have dispute adjudicator boards set up at the start of a project, and these individuals available to you throughout the life cycle of the project. And a lot of the disputes that typically are kept to the end when it gets to arbitration and litigation are disposed of by these boards during the course of the life cycle of the project. And what that means is that if ever there is a dispute that crystallizes, it's already been significantly narrowed.
Thank you very much. Anyone from the audience would like to have any questions? I'm not sure if we have time, but we can take one or two. Yes, can you?
Assalamu alaikum. My question regarding this, using these contracts in Islamic banks. Islamic banks, you know, the banks will be concluding istisna contract with their customers as a contractor, but they are not the actual contractor. Customers will be giving this contract to the actual contract with the contractor. So what's the possibility of how we can use this IBCC in line with, or we can use in Islamic banks when we conclude this istisna contract with the customers? What's the possibility?
Thank you very much. Do you want to take Engineer Vishal this question? Or how can we use this IBCC in an Islamic banking context where an Islamic bank is, financing on the basis of istisna and forward ijara?
أعتقد يعني في كل بنك في قسم خاص، قسم هندسي متخصص بالعقود. على العموم هو العقد يعني صمم وتمت صياغته ليناسب جميع الكثير من السيكتورز، سواء كانت بالكونستراكشن أو حتى العقود الأخرى. تعتمد على إنه كيف يمكن تعديل أو تغيير بعض بنود العقد لتناسب المشروع أو ما يريد تنفيذه من قبل الأطراف. فكبنك ممكن الاستعانة أكيد في المركز خبراء ممكن اللجوء لهم والاستفادة من خبراتهم في كيفية تطبيق بنود العقد وإدخال العقد من ضمن العقود اللي ممكن يتعامل بها البنك في أي مشروع من مشاريعه الموجودة عنده.
جزاك الله خير. Can you pass on the mic? Yes.
Bismillah. Assalamu alaikum wa rahmatullahi wa barakatuh. Most of the speakers are Arabic, so I will lean this time to talk in Arabic. الحقيقة الحاصل أمر يفرح جدا، ولا تجد أحدا إلا جذل بمثل هذه المشاريع. سؤالي أو أسئلة صغيرة لكن حتى يتم لي أنا خصوصا فهم الحاصل. الفروق يعني ما مدى قرب وبعد مثل هذا العقد عن العقود الكونستراكشن المشهورة الفيدك، بأنواع عقود الفيدك المشهورة الأصفر والأحمر والأصفر وغيره. هذا سؤال يعني بمعنى هل كان من الأفضل أن يأخذ الشخص عقدا من عقود الفيدك ثم يسوي له شريعة أبلاينس، أو أنه الفروق عادة إذا صارت كبيرة أو كثيرة لا يؤسس الشخص عقدا جديدا. هذا واحد. الأمر الثاني، رأيت في العقد اطلعت عليه سريعا ووجدت أن فيه تحكيم في الغالب، اللي هي بعض المراد التحكيم على أنه مخصوص بفئة معينة يمكنها IIC مثلا أو الMP. يعني هل من أراد أن يوقع العقد هذا العقد أنه ملزم خلينا نقول هيئة أو مركز أو مركزين لأن يذهب إليها وليس له الحرية إلى غيرها، وهذا أمر يعني لا بأس به، لا بأس به. ثم هل هناك القانون الحاكم له ما دام العقد أصلا إنما أنشئ ليكون متوافقا مع أحكام الشريعة، فالمفترض أن أي خلاف ستكون أحكام الشريعة هي الحاكمة له، هي الحاكمة له. فهل هذا أيضا applied أو لا؟ وهل يعني التحكيم أو الوسائل البديلة لحل النزاعات ليست فقط تحكيم؟ هل وضعتم الميديشن اللي هي الوساطة، ويعني did it fit في هذا العقد الكونتراكت؟ يعني هل هو موجود أو أنه إن شاء الله لعله ينظر فيه مرة أخرى، بحيث أن الوساطة أحيانا تحل النزاع من غير مشاكل، وقد تكون في مرحلة سابقة، في ستيج سابق لمرحلة التحكيم. هذه تساؤلاتي. بارك الله.
جزاك الله خير. This question requires a long answer. Do you want to take on the dispute resolution, Victor? The answer.
Thank you very, very much for the question. I think these are very, very important matters. This contract, well, the first thing I should say is, since this contract was designed and written and conceptualized in an Islamic environment, this is a superior contract to a FIDIC with a bolt-on Islamic part to it. Obviously, if it's designed to work in an Islamic environment with perhaps Islamic finance or whatever other aspects it's been designed for, it's a better vehicle because it's purpose-built. It's an SPV, if you will. It's a special purpose vehicle for running contracts in this environment. So I think that's the first thing I'd like to say. Secondly, this works very well with mediation. I think this is, the people who conceptualized this had mediation in design from the very beginning. So I think that too makes it a more modern vehicle. So I think, yes, definitely mediation. In terms of the arbitration, obviously no one is going to take away from party autonomy. Parties can design their own bits of the arbitration process. So I think it's modern in all regards, and also it's, as I say, it's special purpose built to work in this environment. Thank you.
So I think we are running short of time. I once again thank the panelists for their time, for their efforts, and for an excellent presentation, and all of you participants for a patient listening. I hope the IBCC gets very wide acceptance and adoption. Thank you very much once again.
الحضور الكريم، اسمحوا لنا الآن أن نبدأ في التكريم.
And recognize
أستاذ
to recognize the Mr. Ammar Ahmed, the executive of the CEO of the Dar al-Sharia. Mr. Ammar Ahmed, please proceed to the stage.
المهندسة وصال نعمة، زميل المعهد البريطاني للمحكمين. الأستاذ فيكتور ليجينسكي، زميل المعهد البريطاني للمحكمين ووسيط
mediator. Mr. Leonora Jamgen, the fellow of the EU British Institute for the Chartered and in the field of the dispute settlement, and a chartered arbitrator also. Miss Leonora. Now we will continue the works of our conference, and we will move to the third session titled Innovative Amicable Dispute Resolution Method During the After Contract Implemented Under the Model of Islamic, presented by Dr. Yasser Al-Hassani, the Director of Sharjah for the Islamic Economy Center. And in this session, he has research papers. Ms. Ishraq Ali Abu Taha, in her paper, The Amicable Ways to settle the dispute before and after implementation. Engineer Haytham Mukhtar Abdel Ati, in his paper, The Islamic Arbitration, the Mechanism to Settle the Disputes in the Islamic Contract. Dr. Rami Suleiman Abu Dakka, in his paper, The Islamic Center, Institutional Center for Arbitration, Settlement and Reconciliation for the Islamic Manufacturing, hoping that this session will be rich to consolidate the principles of this conference. Thank you.
In the name of Allah, the most compassionate, the most merciful, praise to Allah, praise and peace be upon our Prophet Muhammad and his followers. This is the last session, and it shall be a beautiful session with this magnificent, wonderful panelists who enjoy academic background and expertise. The session's topic is about settlement and dispute in the Islamic contract for the construction sector. I think Islamic Sharia seeks so many goals, among which is settling the disputes, whether in financial contracts or other contracts. This is quite clear in the financial contracts because people tend to fight and argue when it comes to money. This dispute could be caused because of the contract itself in terms of drafting the contract, or could be to do with the terms and conditions. And dispute could come from the lack of commitment by either party, where either party could be not fully committed to the terms and conditions of the contract. And the dispute may arise out of circumstances out of the control of parties. And it could be also, the dispute could be arise because of misinterpretation of the articles and the clauses of the contract. Today, in this session, in this quite blessed session, we have Dr. Kamal, and he launched this initiative and IICRA, and we have also engineer Haytham Abdul Mukhtar, an arbiter and an expert in financial transactions. We have also the Dr. Rami, the General Secretary of the Arbitration Center. We start at the outset with His Eminence, Dr. Fadal Jamal, with the first topic, that is about ways through which we amicably could resolve disputes during the execution and after the execution as per the Islamic model. Doctor, the floor is floor is yours. You take in behalf of IICRA. Dr. IICRA. In the name of Allah. Thank you, Chairman. Our apologies for Dr. Ishraf couldn't make it due to some emergency, and I'm going to cover this aspect that she should have covered it herself, but I'm going to cover it now. This topic is pertaining to the ways through which the innovative, amicable ways through which we could resolve any potential disputes as per to the IBCC 2025. In this contract, we approved a very innovative way, which it hasn't been used in any other contract worldwide. This method, this innovative method, allows parties not to cancel this board of their resolution. How can that be achieved? It's known on all contracts worldwide that in the event of a dispute or DAB or DRB, which is the board of disputes, this board is being assigned by very independent parties. In other words, three people should be assigned. 3 people should be independent. Whereas, after looking carefully at this article, we realized this doesn't empower this board, which is absolutely independent. This doesn't allow it within a short period of time to come up with a resolution for this dispute. For example, there can be a dispute about the delay, and this delay could take too long time to do analysis and a further study. So there is no time enough to resolve potential issues. Now we talk about the board of dispute settlement. Then after a thorough analysis, we realized it's better to assign people in the project itself. In other words, the employer assigns an individual from his part that represents him, that he knows the project from A to Z. And the other party also assigns a party in this board. Therefore, those two individuals are not independent. So how can we reach to an independent outcomes? Because both parties, they are not independent. The third party, however, is independent. And we suggested that this should be assigned by the Islamic Center for Resolution and Arbitration. What do we benefit from that? We benefit that the third parties that have been assigned, they would listen, the head would listen to the dispute in 2 stages. The first stage, where this committee will sit together and both parties would listen to both parties, and 3 individuals would listen together to the dispute between both parties. As this, they are representative of the employer, and the contractors, they are independent, but actually they are not independent, but they listen to both parties. This is the first stage, where the chairman of the board would listen to both parties. Now, the submission is done. We listen to both parties. The stage is over. Now, the second stage, which is the debate between both parties and coming up with a decision. The debate, since the deliberation should be in a high level because two of them know the project inside out, and the third is independent, which is the chair of the board. The chair of the board would listen from both parties, but would listen to them without the presence of so many engineers or attorneys. They would only, the chairman of the board would listen only to two individuals, which they represent both parties. So the hearing and the head of the hearing can formulate his opinion and can create some kind of reconciliation. So the principle of reconciliation in Islam is based on applying this to resolve the issue. The chairman of the board of reconciliation can come up with a solution that he shares with everyone, and he can make a decision. So the chairman can sign and come up with a solution, can sign the decision. And if either party wants to sign, that's better. So it becomes a final settlement. This is the difference between what we came up with in this contract and the other contracts. Other contracts, they apply absolute independence, but in this contract we realized that the independent the parties can accelerate the coming up to the resolution and facilitate the reconciliation. Thank you for your elaboration. Now we move on to the engineer Haytham, an expert and an arbiter in this topic, to tell us about the Islamic arbitration, the most suitable mechanism to resolve any dispute according to the Islamic contract. The floor is yours. In the name of Allah, the most compassionate, the most merciful, and praise upon our Prophet Muhammad and his followers and his kings. Your Excellencies, Your Highness, ladies and gentlemen, greetings to you all. It's my honor to be here with you in this session to talk about the Islamic arbitration as the most suitable mechanism by which we could settle any dispute in the construction sector. At the outset, I'd like to express my gratitude and appreciation to Dr. Kamal Maras for giving me this opportunity to take part in this magnificent event in construction sector and ways through which we can resolve dispute. This is Haytham Mukhtar. I work as an expert and an accredited court in all the courts in the UAE and some arbitration centers here in UAE, and a mediator and an arbiter in engineering, mechanic engineering, an accredited and chartered arbiter in the energy sector. My colleagues covered or provided a comprehensive coverage about the Islamic methodology in terms of mediation, arbitration. My role is to focus on a particular aspect, which is how can we use Islamic arbitration as a very effective mechanism to resolve any dispute within the contract itself. So where can I start? I would like to say the first point from 1 to 10 that was presented by former panelists talked about the basis of the contract, the structure of the Islamic contract, and risk assessment, payments, delivery, and amicable ways to resolve any potential disputes. All those points have been covered. What I would like to highlight is, I would like to highlight 4 points. The first point is, what do we mean by Islamic arbitration in the context of real estate and construction? And second, why we have chosen institutional arbitration, Islamic arbitration, to become the final mechanism to resolve disputes. Third, how can we read the terms of arbitration in a contract in a practical way? Fourth, what are the tips and advice for both parties when they want to activate this term when it comes to to activate this project? This way, my paper will complement what my colleagues covered. So what do we mean by an Islamic contract in construction? When we talk about Islamic arbitration and construction, we don't mean a monopoly or a different structure. It's the same structure. We have arbiters. We have the final verdict. But the difference here is the reference of the solution. The verdict or the ruling doesn't rely on the Islamic contract. It relies also on the principles and Sharia principles that is relevant, whether in the compensation or determining the contract or dropping some terms and conditions that contradict with Sharia. Here, I need to highlight the points that the contract highlights, which is compatible with Islamic Sharia and may differ from other contracts, which is we need to take into account avoiding injustice, avoiding exploitation, and ensuring transparency, and avoiding gambling. And this can be evident in many points, like how to calculate the compensation without interest, without forbidden interest. Therefore, there is a mechanism to calculate a compensation. How to deal with penalties within a very, very legislative framework, and processing and dealing with the terminating the contract while ensuring fairness with both parties. What we are seeking is a ruling that is fair and just and also applicable in courts, without contradiction with Sharia, without contradiction with the system, because the applicability is the concern of any ruling issued by the arbitration. Why do we do institutional arbitration according to the Islamic law? You may ask, why do we link the Islamic contract with the Islamic Arbitration Center? Why don't we do it with other institutions? The answer is the nature of the dispute has a characteristics. The first characteristic is a dispute, a highly complex technical dispute. The third characteristic is it's based on a contract that's compatible with Sharia, which is not a normal contract. Therefore, that makes it different in terms of not only for the nature of dispute, also the mechanisms by which we deal with the dispute. The Islamic Center provides a mechanisms that covers both elements. The center has experts who have good knowledge about Sharia and not good knowledge in construction. Also, we have ready procedures that could spare us time and effort. And we have procedures about the fees and the arbiters and other points that we can save time. What really matters is the trajectory of settlement that the board of the ADAB, the mediation or reconciliation, no matter the arbitration. This trajectory is aligned with the rules of the center. Therefore, both parties, the employer and the contractor, they get a mechanism to resolve the dispute, which this mechanism aligned with the Sharia and applicable. And this is our target. The condition of arbitration in the Islamic contract. Let's talk about the condition itself in the model, in the Islamic contract model. But look at it from a practical point of view. This term doesn't talk about certain disputes. It refers all disputes to the committee of arbiters, and this includes interpretation of the contract, applying the contract, amending, deleting the contract, amending the contract. This minimizes any potential argument about the articles of the contract in case we have any potential argument about the articles. We choose one arbiter and three in big dispute to ensure we have a consistency or an agreement. The parties, they have terms and conditions about arbitration. Both parties can agree about the place where the arbitration takes place. If they don't have reached an agreement, the arbitration committee could also sort that out while ensuring efficiency. The last point, the decisions of the arbitration, they cannot be cancelled. Those rulings cannot be cancelled, but they can be amended in the light of new data. As such, we see the arbitration clause is not only a sentence, it's part of a system in managing the dispute. Let's talk about the trajectory of the arbitration from the start to the ruling. I'll take you an example. Through a process where we do arbitration from the A to Z. First, during the implementation, a dispute may arise. First, that dispute goes to the arbiters. The board looks at the dispute, looks at the documents, and then it could issue a ruling. Second, both parties may accept the ruling by the committee by the board, or one of the party may refuse the resolution issued or the ruling issued by the board. Within a certain period of time, the point here is not to escalate the dispute to the court or to arbitration. The point is to try to resolve it amicably as soon as we can. So if one of the parties doesn't agree on the first ruling, then they can escalate it to the center. Fifth, the center looks at the demand and notifies the other party and comes up with a committee of arbiters as per the rules and of the center. Six, the mitigation or the debate or allegation starts. Then we start looking at the reports of the experts. We start listening to witnesses. After the deliberation is over, the arbiters committee issue a ruling that takes into account the court and the Sharia. With such series, in this trajectory, we ensure that the trajectory of arbitration doesn't skip any stage, but it goes through the entire process. We still have 2 slides to go. The procedural challenge and the conflict in the steps. One of the most significant challenge is the conflict that could occur between the Sharia and law. We go through four layers of law. For example, the first, we go through 4 different layers of legislation: Islamic Sharia, the country, the law of the country, the arbitration law. Fourth, what both parties agreed on the contract. So we have 4 layers of legislations. The contract may stipulate to apply the civil law, but arbitration can be done in other countries, and implementation can be done in a third country. So the solution is we have to have an accurate drafting for the articles of the contract, and then to choose a place that is compatible with Islamic Sharia to do the arbitration. And lastly, the arbitration has to issue its ruling in line with the contract, and this, as such, we minimize the possibility of rejecting or refusing the ruling or the verdict. The last slide, practical tips and advice. I'd like to wrap up and conclude by providing some tips and advice for the consultants who deal with this contract. First, to all consultants, don't deal with arbitration clause as something random that can be deleted or terminated, because the arbitration clause or arbitration article is a very important article in this contract. Second, to all consultants, try to unify the drafting of the arbitration clause so we can have consistency in terms between all parties. Third, you need to agree on the place where the arbitration will take place. These tiny details on paper can play a pivotal role in terms of accelerating or slowing down settling the dispute. Fourth, you need to make sure that your team, whether technical or otherwise, your team knows about the arbitration, and your team knows about the legal background and technical background of arbitration. Fifth and last, Islamic arbitration should be considered as part of the governance and is not a procedure we resort to in case of when there is a failure between both parties. Look at the Islamic arbitration as a method to protect the contractual relationship between both parties, because it's a good professional way to settle any dispute. Thank you for listening, and it's my absolute pleasure to answer your questions that you may have after we wrap up with this session. I think I didn't exceed my time. Thank you, and greetings to you all. Thanks to His Excellency Consultant Haytham for his presentation, which is quite smooth and clear. And thanks for sticking to the time. And now we, last but not least, and to the best, Dr. Rahim Suleiman, the General Secretary of the Islamic Center for Arbitration and Reconciliation, who will talk to us about the role of the Center for Arbitration and Reconciliation in terms of in the arbitration. Doctor, the floor is yours. In the name of Allah, praise to our Prophet Muhammad. I could see our audience. The audience is our audience is a bit sleepy, so I'll try to be as brief as possible. I'll talk only for 5 minutes because I can see our audience is sleepy and a bit tiring. It has been a long day. So I would like also to thank, I would reiterate, I would like to thank the organizers and who made this contract possible. And I'd like to thank them again and again. For too many years, I've been looking for partners, strategic partners to help me with this project, but I've been blessed, I've been lucky to have my brothers in the drafting committee chaired by Dr. Kamal Malas, who was confident in this project, who trusted in this project. He worked tirelessly. He worked tirelessly and diligently to make this possible. So I would like to thank him again. And however, I will avoid the script and I will talk about what happened during our meetings that we had at the center. The Council of Trustees and the Board of Directors appreciate all those efforts. However, sometimes a member or some people might help you to question what's the point of those contracts? Why do you exert this enormous effort to draft new contracts? And what's the point of what's the message? What's the point of those contracts? I hope that question is limited to the people who ask those questions. Are not. We know for sure that contracts are the foundation of transactions. If we have clear, straightforward contract, a flawless contract, a contract without loopholes, therefore the project will absolutely be a big success. And on the other hand, if we have loopholes in any contract, then the project will be a failure. Our objective is not only to resolve dispute. Our aim, our goal is to have a very straightforward transactions and to materialize those projects and conclude these transactions so each party gets his rights fairly. In the event of dispute, we recommend resolving that dispute through Islamic arbitration in the framework that the Islamic contract is based on Islam.
We have researched and studied with the Auditing and Legislative Committee all the features related to the legislative things through this contract to estimate, for example, the indemnification in case of the termination of the contract or the penalties or the amounts that might be calculated for one party rather than the other away from usury or negligence or non-cognizance. All these things were studied diligently, reaching the final draft of the contract between your hands, and we hope that we will send it through your email to all the participants here on this day, and we wait for your feedback to this or in this contract, and we hope that we will conclude symposia and workshops, maybe directly or online or indirectly, in order to reach at the end findings to develop this contract into 2026 and draft it in a final draft that meet all the desires of all parties. This is what I would like to touch on. The IBCC is a legal art for the Islamic financial industry. Its role is not confined for conciliation and resolving disputes, but it extends to other legal alternatives for the transactions in accordance with the provisions of the Islamic Sharia and in accordance with the best practices, international best practices. From this point, the IBCC has prepared this draft, which is the model draft for the contract or the construction contract 2026 or 2025, and I welcome personally every feedback, every ideas that aim to develop this contract and end it with the final draft that meet all the desires of the customers and the people. And also, I would like to welcome you in this conference. Maybe it is different because most of the audience is from the engineering sector and engineering experts, unlike the events of the previous events of the BBC that included the legal people. So I would like to welcome you in order to be chartered arbitrators for the IBCC and to contribute to achieve its objectives and its message that aim to serve the Islamic finance, particularly with the launch of the UAE to the strategy of the UAE to develop the Islamic economy and the industry of Halal 2031, launched by His Highness Sheikh Mohammed bin Rashid Al Maktoum. May Allah preserve him and protect him. All thanks once again for you, and we are ready to answer any questions or any inquiries you have. We'd like to thank Dr. Rami for this brief presentation and concluding presentation, and we will open the floor for Q&A or any feedback, any interventions from the audience. Please, Doctor, the floor is yours. Or you have a question, maybe. Please give him the mic. Peace be upon you, and many thanks to what you have presented from knowledge and ideas in this conference that is discussing the Islamic construction model contract. My question is to Dr. Rami in regard of that. If we assume that the parties, the owner and the contractor of the contract, put a consent clause saying that we adopted this contract as a reference for the agreement between us. In your opinion, is this enough to cover the other sides of the contract? We know that any dispute can be resolved amicably, and if not, in accordance with the provisions of the contract, it will lodge to the arbitration. Do you think that this contract, in your point of view, is it enough to shorten the time and save the time between the two parties through a simple consent after the consultants review this? Another question, as Mr. Haytham said, I really salute the engineers here who are fully cognizant of the legal sides regarding the arbitration. But what drew my attention is when you talked about the priorities to go back to the application of the subjective law for the dispute. As you mentioned, the legislative provisions that you mentioned and you put the amicably of the parties at the end. Is this a chain or something else? We know that the contract is the Sharia of the contractors. Please, just I would like to inquire about this point. Thank you so much once again. We will answer the question, then we will take another question. We will start with Dr. Rami, please. Of course, whether it is enough or not, is a matter which has a lot of answers. We might say that it is enough in order to evade you the contracts that have many loopholes without mentioning the names or the expressions. There are a lot of concluded contracts And in fact, they have a lot of obstacles before the implementation of the project. In executing the contract itself, there are many difficulties and many challenges because the draft of the contract was not correct or drafted by non-specialists. As we know, the arbitration provision or arbitration clause, when you draft the arbitration clause, there are other arbitration conditions that are not executable or vague or ambiguous. Therefore, if the clause is ambiguous in the contract, therefore you put the problem at the beginning or the ambiguity. The contract we put in the IBCC 2025, I can say that it will pave the way before the execution of the project seamlessly, professionally, without obstacles, through the rights and the obligations control. This is what we endeavor to achieve in the contract. But to guarantee whether there is a dispute or not, this is according to the projects and the nature of the contracts and the parties as well. There are insolvent parties, for example, or other conditions, but when these conditions become there are contingent in this contract, there must be conditions that govern these conditions that happened. And this is the prudence and the power of the contract. Here you can know that this contract is positive and help you, or a contract that impedes you rather than benefits you. Thank you, Doctor. We will move to Engineer Haytham to follow or answer the other question. The part that you asked about the sequence, it is not the order sequence according to the priorities, according to the nature of the dispute. But if we compare, for example, between applied law in accordance with the Sharia, it will become first. So the priority is what the Islamic Sharia stipulates. I hope that this is an answer when we mention the sequence. So the priority is for the Islamic Sharia. Thank you. One more question, please. Thank you so much. Hello, everyone. I would like to thank your unflagging efforts. My question is a question that comes to the mind of everyone who sees a contract where there is a transformation for the or referral to the Islamic Sharia. It is always said the Sharia, Islamic Sharia, can take any sect or any diligence. So lodging to the Islamic Sharia is very necessity rather than option. The legislative standards for IUFI, many companies in the West put a standard for the Sharia in order to get out of the sayings that we know that there is differences and diversification, but in order to enable the person to get out and the arbitrators will not be on dilemma of this, or others select, for example, a sect like Hanbali or Shafi'i or another doctrine or sect. With this, it is aligning with the Islamic Sharia, but in which interpretation, in which meaning? The civil transactions in Saudi Arabia, We have a civil act, we have 700 articles and 95, all aligned with the Islamic Sharia. The arbitrator will be governed by the Sharia, Islamic Sharia. And if he comes and say, no, we have to work according to the options of Dubai Center or Abu Dhabi, I think that is a hated question, but we are talking about a contract with specific standards. This is my question. What is the difference that should be referred to when drafting or the interpretation of the contract? We will transform the question to Dr. Abu Dhaqa. In fact, the rules and the controls for the IBCC necessitates that the arbitrator at the beginning of his job as an arbitrator to identify three core elements: the due diligence law for the dispute, and the procedural law, and the Sharia provisions that should be applied. If we talk about the procedural law, in terms of the place or according to what the parties agree to do that. If we talk about the due diligence law, also as according to the agreement of the parties or as stipulated by the contract itself, or in case of the conflict of the laws, the arbitration authority or the arbitrator will look at the rules of dispute to identify the due diligence center. But according to the IBCC, the arbitrator should select the Sharia, the laws that should be applied. So how can we choose, how can he choose these legislative rules? Either by the consent of the parties to agree on a certain doctrine, or in case of the dispute between the two parties, the arbitration authority will choose which provisions should be applied in accordance with the elements of the nature of the dispute. In general, we have, as you may know, and you mentioned the IOFI, there are legislative standards agreed by all. And many countries that stipulated in its laws that these standards are considered compulsory for the financial Islamic institutions, so they become as a law. And we know that in the UAE, the legislative standards in accordance with the central bank have become standards and have become as a law, and the financial institutions should comply with them. Therefore, the legislative provisions in the UAE and in terms of the Islamic transactions are identified in accordance with the law, so that they conform the legislative standards issued by the IOFI. Therefore, there is no problem with this issue. But if a problem emerges between the two parties, between the arbitrator of the IBCC, the rules of arbitration of the center may allow the arbitration authority to select the legislative standards that should be applied in accordance with the dispute and the details of the dispute. Thank you, Doctor.
Question for Dr. Kamal. We spoke earlier, and you touched upon it earlier today, but that is the role of the engineer, and that the engineer is not impartial, is essentially an agent of the employer, and also that the engineer will be held to account for any mistakes or whatever he made. The question is, does the contract expressly deal with the engineer's role in this regard? Because before a dispute crystallizes, there's a lot of room there for the contractor to be on the harsh side of decisions.
Thank you for the question. Crystallizing the disputes it's an idea came in FIDIC contracts 1987. This idea is not adopted in the Islamic-based construction contract. The role of the engineer, he is administrating the contract between the between the owner and or employer and the contractor. Here, at the same time, we consider the engineer is a deputy of the employer, because in real life, the engineer is not angel, and the employer is not angel, and the contractor is not angel. So this idea could not be adopted. The engineer is inclined toward the employer always. So we put in the contract that if the engineer commit mistakes on purpose, for example, delay the payment of the contractor for no purpose, he will be responsible himself or itself as an office, because capital E engineer. So to pay from his pocket if he make damages to the employer or to the contractor. He is responsible, even he is not party of the contract, but he is doing. So in his doing, he make damages to this party or that party. So according to his own act, he is responsible for his own act. Damages made by him or by it, he will be responsible and pay. So with this idea, he'll try to be neutral because he is responsible. He will be afraid. This is the idea of the IBC 2025. Thank you.
شكرا دكتور.
Intervention. Good evening. May Allah bless you. Thank you for your unflagging efforts. I am Engineer Omar for construction and the lawyer of construction and the fellow of the UK Institute for the Legal Arbitrators. I have asked for the health of the contract within the civil law or the Sharia. We have also the competent that identify the health of the contract, and we have in the Sharia the right contract should include the avoidance of negligence or any bad clause. If, for example, we have a contract and the arbitrator found that this contract is correct according to the due diligence law and the civil law of the UAE, and one of the parties said that this contract is unhealthy in accordance with the Islamic Sharia, is there anything that obliges the arbitrator to overlook the civil law and follow the Sharia, Islamic Sharia? Thank you. In fact, the disposal of the arbitrator before the dispute simulates that there is dispute. I worked in more than 130 arbitration cause. One word only differs or make difference. How to present the dispute in this way might be totally different from the real dispute. One word from here or one word from there makes difference. I think that this contract has an incorrect clause. I should look at the contract and the clauses, whether there are special clauses that nullify the public ones. The contractor Sharia, we have found a paragraph proposed by Dr. Kamal or Rami. He said we should put in the special clauses a paragraph to refer when there is a contract between the special clauses and the public, so the private clauses will prevail. So we should look at the special clauses, what is written, and then resolve the dispute. We cannot resolve the dispute in general by saying this contract will apply this or that. The contract also was edited and written to give flexibility to the parties. It is not rigid or frozen. It can be developed, it can be updated. As Mr. Rami said, we have a 26, 28, 27, 28. So it is developing over time. So it has no fixed frame. There will be more than one answer in every development process. Let me add something to the question. Many people in this ask this question: what if the Sharia conflict with the provisions of the law? In a brief, this is the question. What if the Sharia conflicts with the provisions of the law? And I ask, what is the origin of the law? It is the Sharia. So how conflict becomes? The theory of the contract in the Islamic jurisprudence is what is based on the law. So the consent of the role and the acceptance is the base of the Sharia. Over my 20 years of arbitration, I have not found a party that says that this contract is illegal or unhealthy in accordance in terms of legislation or Islamic legislation. What happened is the dispute of the implementation, not the essence of the contract. Therefore, in the Islamic Sharia, the pillars of the contract are stipulated in the law and they are taken from the Islamic Sharia. So the pillars of the contract are the same of the contract is unhealthy in terms of Sharia. Otherwise, these will be theoretical things and which are unexisted or unacceptable. We would like to thank. Any question? Okay, this will be final question, please. Peace be upon you. Thank you for your presentation. I have inquiry for Mr. Rami, Dr. Kamal. Did you think to put an article in the contract to look at the arbitration, the mediation, and then arbitration? Mediation, then arbitration. This issue is utmost important, but we did not put it in the contract simply because the arbitration rules in the IBCC include special rules for the reconciliation. So any application for arbitration reached the IBCC must be in accordance with the rules of the IBC, and this suit say that the arbitrator should ask the two litigant parties or disputed parties whether this litigant has covered all the ways of reconciliation. If the answer is no, the two parties should lodge to the rules of reconciliation that are found in the IBCC, which are the rules that enable the two parties to look for the amicable reconciliation. But we have found what we have found on the ground that many use these rules and conditions for the amicable reconciliation to delay and impede the procedures of arbitration. Here, the authority for the discretion authority for the IBCC within the framework of the real reconciliation, or are there formative or formal procedures? The IBCC does not have the staff, does have the technical and the staff that can estimate whether these procedures are credible and or they tend to impede and delay the resolution of the dispute. In the end of this session, we would like to thank the panelists and the audience for listening and staying with us, and peace and blessings be upon his messenger Muhammad. Ladies and gentlemen, in the end of the fourth session of our conference that came to the reconciliation of the disputes and the arbitration in the Islamic construction contract, we would like to thank and appreciate everyone who contributed to bring this session to success, and we will come to recognition of the speakers. Dr. Yasser Al-Husani, the Director General of the Sharjah Islamic Economic Center. Engineer Haytham Abdel Ati, mediator and arbitrator, expert. Dr. Rami Suleiman Abu Dakka, the Secretary General of the IBCC. Dear esteemed guests, we come to the end of the international model of Islamic-based construction contract, IBCC 2021, under the slogan Balance the Clauses and Innovative Methods for ADR, which is held under the patronage of the Ministry of Justice and with the presence of His Excellency Abdullah bin Sultan Nuaimi, the Minister of Justice, and in accordance with the IBCC also, and in participation of an elite of researchers and experts. And thanks are extended to the sponsors and the partners through the discussion of the 4 sessions. We have certain recommendations that prelude to continue the discussion on the second day, which are represented by Dr. Rami Suleiman Abu Dakka, the Secretary General of the International Islamic for Arbitration and Reconciliation. The floor is yours, Mr. Abu Dakka.
Greetings to you all. In the name of Allah, today's in 22nd Jumad, and today 13 November 2025. The international model for the Islamic-based contract, IBCC 2025. Under the slogan, balanced articles and innovative methods to resolve disputes. I'd like again to thank everyone who attended this conference. I'd like to thank your valuable inputs that you shared with us. We've received your feedback and inputs. We've received some feedback from you, from our participants who enjoy experience and expertise. We've written those recommendations. The recommendations as follows: dissemination and development of the contract, distribute the model Islamic-based contribution contract IBCC 2025 in both Arabic and English, while collecting feedback and recommendations from practitioners, carefully reviewing them and issuing an updated version to be launched by the IICRA at the next conference in 2026. Enhancing training and capacity building, intensifying training and capacity building efforts by relevant authorities, including the Institute of Training and Judicial Studies, the Ministry of Justice, and the Sharjah Center Islamic Economics to develop professional and legal and technical professional in the legal Sharia and technical aspects of the model Islamic-based construction IBCC 2025. Third, dispute resolution services, broadening the utilization of the center services, particularly institutional reconciliation and attribution in compliance with the provisions of the Islamic Sharia through the implementation of the contract Islamic contract IBCC 2025. Fourth, supporting the Islamic financial infrastructure, strengthening IICRA and the related infrastructure institutions of the Islamic finance and Islamic industry to develop institutional model contracts regulating Islamic financial transactions similar to the IBCC and to advance the Islamic practices. It's worthy noting that the Center is an international independent organization and is recognized as one of the most important infrastructure institutions and legal arms of the Islamic financial industry. It's the only institution of its kind based in the UAE, providing its services to the Islamic financial sector. In conclusion, I would like to thank everyone. I would like to thank everyone who has attended today, and I invite you to communicate with our center to benefit from our services and to exchange expertise and to benefit more and more from our knowledge and our heritage, the heritage of the jurisprudence of Islamic transaction. I would like to everyone to take a group photo. Kindly come to the stage for a group photo.